All right. Good morning, everybody. Welcome to our to Sentry Management's presentation of the HOA Board Member Certification class. Before we get started with some housekeeping and how you will interact today, I'm going to turn it over to Ashley Northrup of Sentry Management. Ashley, our host, the floor is yours.
Thank you, Jeff. Good morning, everyone. My name is Ashley Northrup. I'm with our Learning and Development team here at Sentry Management. I just wanted to introduce Alan Schwartzseid, who is going to be presenting the class today, as well as Jeff Solomon, who just did the introduction for myself. Thank you so much. We really appreciate you helping us with our board certification classes. And after the class today, please feel free to reach out to me and our team. You'll have that information provided to you. If you have any follow-up questions or needs, we're here to help you. And then look out in the future for other educational events that we'll be hosting with Alan and Jeff, as well as other educators. So thank you again so much. I really appreciate and I think you guys will all really enjoy this class. I've sat on the classes that Alan has done. They're fantastic. And this one is very much based, it's all based on the HOA side. So you'll get all of the content that relates specifically to HOAs. So you're not going to hear condo stuff. And it should be very beneficial and educational for you today.
I want to now turn it over to our managing partner over at the Orlando location in Central Florida, Alan Schwartzseid. Alan, that's a mouthful. The floor is now yours.
All right. Thank you, Jeff. Appreciate the introduction, and thanks again to Sentry for having us here today. Wanted to just briefly go through a little bit about the firm, just so that you know who's actually teaching you today. We've been in business since the 1990s. The firm does nothing other than represent community associations, that's condos and HOAs, throughout the state of Florida. As Jeff mentioned, my name's Alan Schwartzseid. I manage the Orlando office of the firm. We've got additional offices in Tampa, Palm Beach Gardens, and Pompano Beach. 8 of our attorneys out of 21 are board certified in this area of law, another board certified in construction law. So we really try and be full service, but only to the community association industry. We're not masquerading as a community association firm, but really we focus on family law or real estate. This is what we do. So we've got a lot of slides to cover in just a little bit of time, which means I have very little time to spend on each one. So I'm not going to waste your time with my background, but just so you do understand very briefly, this is something that I do on a regular basis, teaching board members, community association managers, other attorneys, how this area of law works. If you've got any questions that I don't have time to cover today, feel welcome to reach out anytime. I'm going to ask that you at least wait until the end of the class, because I tend to get 10 to 20 emails just while I'm still teaching. Hopefully I'll cover your question while we're teaching. And if not, I genuinely welcome you to reach out. You're going to get the slides. Once you fill out your survey today, you'll get your certificate, as Jeff mentioned at that time. And my email address, as@kbrlegal.com, is right on the slide that's up on the screen right now. So if you'd like to reach me, that's going to be the easiest way. I also try to share something helpful on LinkedIn regarding this industry, or just being a Floridian as a whole, at least once a day on LinkedIn. So feel welcome to follow me there. Now into the material. Why the heck are we here? Well, right now, and this is about to change next year, and when I say next year, I mean in a couple months, I think. But as of right now, you've got 2 options as to how you can be certified to actually serve as a member of an HOA board. One is you do the smart thing. You take a class like this with someone who hopefully knows what they're talking about. And you learn a little bit about what it means to be a board member, what your obligations are, what are some of the legal pitfalls that you might be able to avoid by doing it the way that we're suggesting today. And you're basically submitting the certificate you'll get at the end of this class. The alternative, which is an option right now, and I believe as of July of this year, will no longer be an option to do as the exclusive remedy, so to speak, is going to be, you can have a certificate that's basically a piece of paper that doesn't mean anything, that you sign, that says, I've read the governing documents, I'm going to do my best to uphold what's in them, I kind of understand Florida law, and I kind of understand what the documents say, but I can promise you from experience, when you try to read through those documents, I don't even understand what half of them say because they're so poorly drafted. And that includes some of them that have been amended even recently. Now, you go back to some of the HOAs that were formed in the 70s, the developers back then, you know, I've literally got a community that's got a total declaration of 2 pages. I've got others that have literally 75 pages worth of just junk. So my suggestion, you're doing the right thing. Make sure that your other directors do the right thing by taking a class like this, because again, it's going to be required once the governor signs the bill that's pending right now before the Florida legislature as of July of this year. Now, the other thing to keep in mind, you can take this class up to a year before you serve on the board, meaning if you're not on the board yet, but you decide to get onto your board during an election, let's say your community does things a little oddly and you're holding your elections in July. This certificate from this class will still be good for your HOA board. You can do it up to a year before, but you must do it at least 90 days, or I'm sorry, up to 90 days after. If you don't sign a certificate or get your certificate from this class, understand you are suspended from service on the board. That doesn't mean you're completely off and your position gets totally replaced. Okay, you're still going to be a director once you finish this class or you sign that certificate, but until that's done, you're suspended. You are temporarily off the board. Now, there are differences between condos and HOAs. Fortunately, we don't have to do the class for both today, as I mentioned earlier. So I'm going to skip a little bit of this. We'll talk about most of it later, but I did want to include the information so that you can see some of the differences between a condo and HOA. HOA is really a creature of the contract, the declaration. Okay, that's your CC&Rs. A condo is a creature of statute. What I mean by that is if the statute that says you can't subdivide this building didn't exist, you wouldn't be able to do it. So in a condo, you basically have a bunch of land that's divided up, and you can really have a plot plan that shows you, your plat shows you where those lots end. Okay, really a survey shows you that. But the bottom line is we are different. So don't look at chapter 718 is what I'm getting at, which is the condo statute, as governing over your community if you're in an HOA, because I can promise you it's not. Nothing in chapter 718 that I'm aware of has any control over the operation, maintenance, or anything else related to an HOA. So we're talking about 2 chapters here. One is chapter 720. That's the HOA Act. So that's the one that you're really going to be looking at and you're looking at, hey, this is where we're at. We don't look at anything else. So if you're in here and you are in a condo, I'm sorry, but you're in the wrong class and you should be signing up for the next class, which is, like I said, is going to be taught next Tuesday. If you get a certificate for the wrong type of community, it will have 0 value to your community, even if it has value to you. Moving along. Like I said, we'll skip through some of the differences between HOAs and condos. Yeah, all of this is covered elsewhere, so we'll skip it. So we get into the question, okay, well, we've got statutes that we're talking about here, the chapter 720, and there is another statute that we'll get into later. But if you're looking at just chapter 720, which version of the statute applies? Is it the one that's in effect now, meaning the 2023 version? Or are we talking about the one that was recorded and adopted the date that the declaration was recorded? Keep in mind, Contract Law 101 is what it says here. Whatever substantive law was in existence as of the date of a contract is basically grafted into that contract. What that means for practical purposes is your substantive rights, your valuable rights, not the procedures of how the association operates, but your right to vote, your right to own the property, your proportionate share of the common expenses and surplus. All that stuff is set forth the date that the declaration is recorded. And unless the declaration says otherwise, whatever's in the statute as of that date is going to apply. Now, there are exceptions to this, okay? When we're talking about procedural changes, how you hold your elections, things of that nature, it's entirely feasible that a change in the statute is going to apply across the board, regardless of what's in your declaration. Now, this is really a legal analysis that your lawyer should be doing, not the board. You should never be deciding which portion of the statute applies or which statute applies or whether it supersedes your governing documents. That's a legal question that your attorney should be answering. But I know that some HOAs simply don't pay attorneys because they don't care about getting accurate legal conclusions. My recommendation is always have a manager that knows what they're doing, have an attorney that knows what they're doing. Those are your business partners who are going to guide you through making good business decisions that the board gets to make. You get to make the decision, but if you're making it without information, you're pretty much guaranteeing that at some point that decision is going to be the wrong one and you won't even know it. So get the legal opinion. Does the declaration apply, the CC&Rs? Do you have this language that we call Kaufman language in your declaration? If so, if your declaration says that it adopts the Chapter 720 or the HOA Act or the Florida statutes, here's the language in bold here, as amended from time to time, then every legislative change is going to apply to your community, whether it's substantive or procedural. Okay. If you don't have that language, then there's another analysis that needs to be performed. Now, I've got it in the slides here, but again, I don't want you to think that just because this is information that I'm making available to you, Sentry is making available to you, KBR is making available, that you should be relying on it and making your own legal conclusions. Okay, that's what lawyers are for, legal conclusions. So if you're not 100% certain based on prior legal opinions, you should be getting one as to whether the statute in current form applies, whether the statute in previous form applies, or whether your governing documents supersede the statutes and will control in any particular situation. So just some examples here of substantive versus procedural rights. I'm not going to go through them in detail, but I did want to make sure that you guys have this information. Moving on, and I know that I'm kind of blitzing through some of this again. My purpose is just so that you're aware of some of these things and that you know to go to your attorney, not just presume that what's in your declaration, what's in your bylaws, what's in your articles is going to control over a statute or vice versa. I frankly do not have the 12 hours it would take to go through all of this and make sure that you're aware of all of this, okay? You will be provided, as we mentioned before, a copy of the slides once you've completed your survey today. So don't worry about not having these slides right now. You're welcome to look back through them. I know you have all the time to look through 188 slides at your leisure, but the bottom line is at least now you'll have the information. So I talked about there are 2 chapters of the Florida statutes that are really relevant to your HOA. There are a couple more that we might get into, but the main ones are going to be Chapter 720, which, as we mentioned, is the HOA Act. The other one is Chapter 617. This is the Not-for-Profit Act. And what it does is controls the operation of not-for-profit not-for-profit corporations. And whether you understand it or not, what you're doing is running a corporation. If you are a director or you're a CAM, you're responsible for the maintenance and operation of a community, and that community is governed by a business, a corporation. You're not trying to make $1 million on that corporation, but it is a corporation. So make sure that you are aware that it's not just Chapter 720 that your attorney should be looking at. And when your attorney isn't aware of Chapter 617 potentially being relevant, that's not an attorney you should be working with, because they don't understand this area of law if they're not aware that there are 2 interacting statutes. Now, the major thing to focus on is when there's a conflict between these 2 statutes, and understand, just like a conflict doesn't arise between governing documents just because they govern different aspects of an issue, a conflict doesn't arise here just because there are 2 different aspects of an issue being addressed by the statute. Okay, but if there is a conflict between 617 and 720, 720 is going to control every single time over 617, meaning the laws governing your HOA are going to control over the general laws governing corporations that are not for profit every single time. Again, this is an attorney issue. That's one I want you to be aware of. It's not one that I want you to make the decision on your own as non-attorneys or attorneys who are not well-versed in this particular area of law as to what the law says. Moving forward, I mentioned your declaration. Let's go through what your governing documents are, because there's also misconceptions about these. Okay, first we've got your declaration. Okay, and just remember, if you want to remember the order of operation, the order of importance, the order of discretion that is given to these documents and credence that's given to these documents, Remember the old expression, a little dab will do you, DAB. Okay, so we're talking declaration, articles, and bylaws. Your declaration is the covenants, conditions, and restrictions. Sometimes it includes easements and other junk, but it's the document that is basically the constitution of your little community. And there's case law that essentially says every community association is basically a small governmental unit. Don't think that that means that an HOA's actions are government actions, totally separate. First Amendment might not apply, things like that people bring up, completely separate, but it operates similarly where you are basically a self-contained city. Okay, so that city is governed by your declaration. It's a contract that binds the members, it runs with the land. It's recorded, importantly, before any of the deeds that transferred ownership of any of these lots to any of the owners. What that means under Florida law is that it's first in time and is first in right, meaning the declaration actually supersedes. So if this is why, by the way, we're allowed to enforce covenants, tell people that you can foreclose their home, because the declaration includes all of that, was recorded first, and therefore supersedes everything that's in that deed. Okay, now I say that there's a declaration. Some communities just have deed restrictions that are recorded with each deed. That's generally not going to be governed by Chapter 720, but it might be separately. Okay, it depends whether there are assessment rights and certain other issues that, again, you're going to want to consult with an attorney to determine whether you're an actual HOA or just a deed restricted set of lots. But understand that your declaration, everything that's in here, is basically presumed to be valid unless it's arbitrarily enforced or there's some Florida case that says this specific provision cannot be in a declaration, and if it is, it's totally unenforceable. Okay, I'll give an example of one of those provisions. Yeah, you can have in your declaration that Jews aren't allowed to live in your neighborhood, but that wouldn't be enforceable because it's clearly discriminatory. And it would be something that a court would basically say, no, I'm sorry, you can't do that. Generally speaking, though, anything that's in this declaration, it's presumed that the members agreed to it because the declaration was recorded. It said that it could be amended, and then the owners bought in. Okay, so just be careful about amendments. We do have a separate class on that subject. Most of them will apply across the board, but when it comes to certain leasing restrictions and things of that nature, just understand it may only apply, depending on the wording of the amendment, it may only apply to the people that buy in after that amendment happens, or the people that actually signed on to it and voted in favor of it. Just something to throw in for fun there. The Articles of Incorporation is the next most important document. It's basically going to state the name and purpose of the corporation. Sometimes it will also say who the officers and directors are, what their liabilities are, what their abilities are. But most of that information is going to be in the bylaws. Most people think that the bylaws are going to control your day-to-day operation. They really control how the meetings are run, when and how you have your annual meeting, how you do your elections, how meetings of the members are done, the directors and officers and what their responsibilities are, if there are any qualifications to be a director or officer of the community, etc. And then finally, you've got your rules and regulations. That might be actual rules and regulations. It might be architectural criteria. It might be other items, policies, and things of that nature. And because these are generally made by the board and not voted on by the members, it's just, hey, the board decided this is going to apply. It's not really given a whole lot of credence by the court. There is a specific test that the courts will follow. So rather than just adopt these rules and regulations, I'm going to recommend that every community association that's looking to do that, run those by their attorney and make sure that it passes that smell test that the courts are going to apply. Because keep in mind, you can adopt 80,000 rules and regulations, but if only 5 of them are enforceable, they have zero value for your community other than to potentially get you in trouble and get you sued for trying to enforce restrictions that really don't apply to your community. The major thing to keep in mind with respect to these rules and regulations, these board-made requirements of your community, is that they can't contradict the declaration, the bylaws, or the articles, and they have to be reasonable, generally speaking. And they have to be somewhat supported by the declaration, articles, or bylaws in order to be enforceable as well. There's more that goes into the test, but just understand you might have an issue enforcing these things if you don't at least run them by counsel who's competent in this area of law. The other thing I'll mention is one of the most popular amendments that I've done in the past is just making it easier to vote. There are two ways to do that. One, the board can adopt electronic voting so that it doesn't require even a mailer, let alone showing up in person, to have the members vote on issues in your community, including amendments in your election going forward. The other one is amending the actual amendment requirements and quorum requirements for the future amendments to take place. So if you're having trouble and you think, well, there's no way we're getting a 2/3 vote to adopt leasing restrictions in our community, it might be easier to do that if you start with an amendment to reduce that requirement in the future and adopt electronic voting so that people have an easier time of voting. That also enables them to opt into electronic notices, meaning that some of the notices we'll discuss today, you don't need to mail them out. They just go out via email or fax and it's done. Or potentially, depending on what you're doing, just put them up on the website and that's the notice that these people get. So it can actually save you a lot of money, even though you're spending money on the electronic voting platform. Sometimes it's actually the exact same amount of money. And there are some vendors who will try and make it the same amount that you were spending before per lot to swap over from physical to electronic notices. Members' rights and meetings. So let's move on to annual meetings, which I mentioned a minute ago. You have to have one every year in accordance with your bylaws. Pretty straightforward. The bylaws in an HOA will generally say when and where you need to hold that annual meeting, how to call it, etc. Now, any meeting of the members that's not the annual meeting is a special meeting. It doesn't mean that, oh, we're having a very crazy issue to be dealt with, so it's a special meeting. It's literally anything other than the annual meeting. It's anything that's not the regular meeting. That's held when the board calls one or a written request of at least 10% of the members. You might have a different percentage in your governing documents. If so, it'll be that percentage. But when the members actually ask for a meeting of the members to vote on a specific issue. So understand, your members, generally speaking, can probably propose amendments to your governing documents, propose to do certain things with contracts that the association enters under certain circumstances. So don't think that the board gets to control everything, but I will fully acknowledge the board does control most of the decisions that are made for the association. When you're sending notices, just understand it's the owner's obligation, not the association's obligation, to make sure that if they have provided a separate mailing address that's not the property or a separate email address, that they're keeping the association up to date and providing the right communication information. It's not the association's responsibility to chase these people down. So if someone claims, oh, well, I haven't gotten notices for the last 5 years and you guys knew I didn't live here, why didn't you send me notices? An appropriate response from the association is, yes, we knew you didn't live here. You didn't designate a separate mailing or email address so that we were allowed to send you notices to a different location. So just a little pro tip there for you. Moving along, special meetings, notices, and agendas. Generally speaking, unless the bylaws say that you need to give specific notice to the members, the association needs to give 14 days mailed notice to the members for an upcoming member meeting. That applies to amendment votes. It applies to elections. It's just going to depend what's in your governing documents. The notice needs to be mailed or delivered to the address given by the owner in the official records of the association. This is why you're not just going ahead and updating the association records until the owner tells you that, hey, I have a separate address. Moving forward, all notices must provide the date, time, and location of the meeting. Bottom line, it's not a proper notice if you're not telling people how to actually attend this meeting. It doesn't help them that you gave them notice, hey, we're having a meeting sometime in the next 5 months. Okay, good for you. When, where, and how can I attend are the important criteria that they need to know about. You can adopt a procedure, like I said, for broadcasting notices or putting them on your website. Now, every meeting of the association, that's for members and for the board, needs to have an agenda. This was not the case in Florida HOAs until less than a year ago. Okay, but just understand, if you were not aware of that change that took effect, I think October of last year, you need to have an agenda for every single meeting. You cannot address items that are not on the agenda at any meeting. So that is one way that I've helped communities control when members want to talk about 80 different issues. If it's not on the agenda, it's not being voted on today. Sorry. If you wanted it to be brought up at the meeting, you could have gotten your 10% or whatever percentage of the members were supposed to provide a petition to have a meeting regarding that particular issue, or you could have at least let us know in advance that you wanted us to address it so we could consider putting it on the agenda. Okay, the other way you can control that is having an adopted policy governing member speech and participation in meetings. That's one of 6 policies I think every single community in Florida should have. So again, that's number 1, member speech and participation at meetings. Business conducted at these meetings is limited to the purposes described in the notice. So you can't just throw things at the wall in the middle of a meeting and make a decision. What the board and the members can do is ratify a decision later, but I don't think the members can do that. The board can. We'll get to that later. But you can't just deal with another issue and then, deal with an issue that's not on the agenda and then have the members ratify it later at a meeting 6 months later. It doesn't work that way. The decisions of the members need to be made at the meeting or in conjunction with the meeting. Let's see. I think I covered everything I wanted to here. Again, members have the right to participate in meetings. This is why I think it's important to have a policy like I just mentioned. So every member can attend, speak at, and record every meeting except for closed legal meetings and closed meetings to talk about actual employees of the association. Every member meeting, the members get to attend. They get to speak for at least 3 minutes on each agenda item. And if the board adopts these written rules, you can control the time, frequency, and duration of how members get to speak. You can say you get to speak before or after the board gets, or the decisions are made, etc. So just understand that, generally speaking, the president is going to preside over every meeting, whether it's the members or the board that are holding the meeting. But it really comes down to, are we talking about an issue of the members voting and it's a member meeting, or is it a board meeting where the board gets to vote? Understand, your members get to speak at board meetings. They do not get to vote at board meetings. So that is an issue that comes up fairly frequently. I don't put it in the meeting note, the meeting policies that I draft, but I have had some communities ask for it, so I've allowed that to go in. You do have to have the member meetings at a location that's accessible to physically handicapped persons if it's requested by that person in advance and they have the right to attend the meeting. It's not your obligation to hold every single meeting at a handicapped accessible location unless someone has stated they have a disability and need that accommodation. That said, it's still my recommendation to do it at a handicapped accessible location so that you don't have to deal with that inquiry and worry about policy number 2, which is disability requests. Okay, Fair Housing Act issues, Americans with Disabilities Act issues, although the ADA shouldn't really apply much in an HOA. But those disability-related requests are another policy you should be creating. You should be having a form that makes it easier for the association to consider those requests. Not a form that's required of the members or the residents or the people who are asking for an accommodation, but that helps them get the information that the association needs to go through its decision-making process regarding those accommodations and those changes to the property. We have a whole separate class on that issue. It's later on in the slides, but now that I've mentioned, I can kind of skip it. But the bottom line is that's policy number 2, is dealing with disability-related requests. The policy that I generally prepare is a step-by-step guide as to how the association should be dealing with those issues so that you don't have to reach out to counsel every single time you get the request. Because if you get hit with one of these disability-related requests and the owner or whoever requested the accommodation claims that you didn't provide the accommodation, there can be huge, huge sanctions. And even if you win that kind of dispute, you don't get your fees and costs back, meaning you spend a bunch of money to try and take care of the issue. And even if you win, you lose. Okay. Terry, thank you for your question. I'm going to answer some of these if I happen to see them pop up, but I'm not going to be actively looking at the Q&A. We'll deal with most of it later. But since it's relevant to this issue, yeah, handicap accommodation requests that an owner asks for, keep in mind there are two separate concepts. One's an accommodation request, which is just, well, we need you to change your rules and how you operate. Modifications are changing the property. If it costs money, that requestor is generally going to be obligated to pay that money in order for the association to provide the accommodation. So just understand that generally speaking, you probably will have to provide these accommodations if you've gone through that interactive process and you see that the owner or whoever's requesting it is entitled to the accommodation. That was a lot of words to say, hey, do what you got to do, but make sure that you've got a policy that actually shows you what you've got to do, rather than spend an hour or 2 hours of attorney's fees every single time a request is made for an accommodation. Moving forward to quorum and decision making. Unless a lower number is provided in the bylaws, in an HOA, the quorum is 30%. Okay, member decisions require a majority of the votes during a meeting at which a quorum is present. That doesn't mean it always requires a majority of the members. Although keep in mind, for amendments and certain things, you might need that majority or 2/3 or whatever the percentage is of the entire membership versus that percentage, a majority of the voting interests. The vast majority of what you're going to be dealing with where your members are voting is going to be a majority of a quorum is what you need to adopt what you're trying to adopt. Moving forward, proxies. So proxies can generally be used, not a general, but a limited proxy can be used. It needs to be dated, include the date, time, and place for the meeting for which it was given, and be signed by the person who authorized the proxy. What does this mean in plain English? A proxy is basically a document that says, hey, you can vote for me. But it is specific to the date, time, and location of a specific meeting. Now, if that meeting doesn't take place, because even with the proxies that were given, there was no quorum or you weren't able to hold the meeting for whatever other reason, just understand that this proxy is still good as long as that continued meeting, basically the rescheduled meeting, is held less than 90 days out. Okay, so once that 90-day time frame hits from the date of the originally scheduled meeting, sorry, but that you need a new proxy. It's no good anymore. That proxy can be revoked at any time by the person who signs it. So keep in mind, we're talking about when you get these proxies in for purposes of your election, your amendments, okay? That can be revoked at any time until it's actually been submitted. Once it's in the ballot box, so to speak, from my perspective, any additional vote that is cast by that person will be a second vote and cancel out both votes. Okay, the proxy holder can appoint someone else, meaning I pass it to you, you pass it to even another person because you're not able to attend the meeting even though you thought you could. Any proxy holder can appoint a substitute, and a copy of an original proxy can be used if it's a complete copy of the entire proxy, not just, well, here's my signature page. We need to see all of the information that's listed in that first bullet point in order to know that this is actually a valid proxy. We talked about general. That's basically, hey, vote however you want on this matter, but still at a specific meeting. A limited proxy is going to limit the issues that proxy holder can actually vote for. It's basically, I'm handing you my ballot almost, but it's not a ballot, it's a proxy, and saying you vote this way, but I can't make it to the meeting, so you hand it in for me. That's really what we're talking about. Or it could be mailed. You can use either to establish a quorum. We've got a bunch of, again, changes that were made in the last year. So we've got flags. Now we're getting a little bit into covenant enforcement. That's policy number 3, by the way, that I think everyone should have. How are you actually going to enforce violations of your rules, your regulations, your covenants, conditions, restrictions, etc.? That's basically going to say, hey, the manager is going to send out a couple notices. It goes to council. Are we or are we not going to perform self-help, go onto a lot and actually cure the violation? There's a lot that goes into it. I have a class on that as well. And any classes that we teach, just understand that they will be available, including this one, in a few days. is going to be available on our website on the resources tab at kbrlegal.com. I don't know if Sentry will be posting this one as well, but that covenant enforcement class, you're welcome to just go ahead and check it out. It's free. It's basically watching it on YouTube. So have at it. But some of the more pertinent issues, other than making sure that your enforcement efforts are done timely, consistently, and uniformly, which that policy makes it a lot easier. But some of the most important issues are, what can't you regulate? So let's go through a couple of those. It doesn't matter what your governing documents say. An owner can display up to 2 of the following flags in a respectful manner: the U.S. flag, the state flag, military flags for the U.S., a POW MIA flag, or a first responder flag. Keep in mind also, you can have a freestanding flagpole with at least 1 U.S. flag and one of the other ones that are listed in this slide, as well as what's on your house. So technically, you could be flying up to 4 of these flags at any given time on one lot. So just be careful when you try and enforce and say, well, you've already got 2 on your house, you can't add 2 more on the flagpole. Unfortunately, yeah, they can. And I've seen several lots that had 4, and sorry, but my answer is there's really not much you can do about that if it is the 4 that are allowed here. The other one that came out last year, which is an abomination in my opinion, but the legislature does that sometimes, is statute 720.3045, which is basically the rule that says anything that's not visible from the frontage of the lot or from an adjacent lot is not enforceable. Now, I say anything, understand, this law is very selective, meaning it doesn't govern every violation or everything that's on a property. It talks specifically about things that are installed, displayed, or stored. So we're talking about things that someone shoves or installs onto that lot and leaves there. That could be a boat that's stored on the lot. It could be pavers that are put down. It's not the condition where someone's in the backyard screaming, and because you can't physically see it, it's not enforceable. That's not the case here. So when someone does put down those pavers in the backyard, and because of those pavers, the drainage is terrible in that area, and you start to have trespassing water from that lot to the neighboring lot or the common areas, that trespass of the water, that damage that might be done as a result, is still an enforceable violation. So don't think that you've got no rights just because something happens in the backyard and you can't see it. Other things that I've mentioned in the past, if you can look above or around the fence, if you've got, the next door neighbor is a second story and they can look over the fence and look down into that property, it's visible from an adjacent lot, whether the owner wants to acknowledge it or not. And it is enforceable regardless of this statute. I won't get into whether I think that this statute is constitutionally appropriate and allowed, because, well, I will get into it. I don't think it's constitutional because it interferes with substantive rights that the association might have had since the 1970s. And the legislature suddenly thinks that they can overrule everything that's in the Declaration that restricts these issues. But whether or not you want to spend the hundreds of thousands of dollars to get this up to the Florida Supreme Court, I'm not aware of anyone that's been willing to do it. If you want to, please feel free to reach out to us because we'd be happy to work on it for you. Now, what about the view from across the lake? The lake is not an adjacent lot. Okay. If you've got one lot here, and yes, I'm looking to make sure I'm on camera here, and you've got a lake here, this is not the adjacent lot to this one. The lake is adjacent to both of them. So it's just a poorly worded statute. It's a bad idea in the first place. And in my opinion, it's something that many communities will ignore, both because of the constitutional issue and because the members have to raise this issue in order for it to be enforced. And if a judge understands the concept of, well, this installation is not the violation, it's the additional violation that installation created because of problems that happened. Not mentioned here, the over-the-air device rule, which means you have to allow certain satellite dishes, the energy device statute, which I think is under chapter 163, which says that you have to allow certain solar panels and solar collectors, meaning also skylights, even if you have an HOA that you have shared roofs that people need to dig into. There are, certain things that you can require. in those types of situations, like assurances that any damage that happens to the roof, any loss of warranties, etc., is going to be covered by that owner. But just understand, the problem is going to be that you're going to be in a situation where they've got a statute on their side if you try and enforce any of these things, but you still have the ability to enforce them. We talked about the Fair Housing Act, Americans with Disabilities Act, and the accommodations that you need to have for those types of things. So basically the bottom line is, yeah, go ahead and send out the violation notice if there's a violation, but beware that it may not be a violation under Florida law. You might not be able to control some of these installations. Now, we've had questions about, from the frontage, does that count the garage door being left up and the interior of the garage is an eyesore? If that's a violation in your community where your declaration, your rules and regulations specify that an eyesore is good enough to be a violation and just looking like crap is a violation in and of itself, then yeah, that's visible from the frontage and it's an enforceable violation. It's not impacted at all by this law. Same thing with is visible from an adjacent lot. Does that include the roof of a shed that's above the fence line? Absolutely, it does. Now, when it comes to the satellite dishes, the solar panels, understand that both of those, you can restrict the location of these things, but not in a way that's going to negatively impact the ability of that thing to function. So if you're going to impact the satellite dish's effective signal, then you might not be able to say you have to have it in this particular location that doesn't work for purposes of that thing. Moving forward. Okay, members have the right to know what they're going to be subjected to when it comes to architectural standards. So if you want your architectural standards to be enforceable, they have to be specifically stated in or reasonably inferred from your declaration or architectural criteria that are supported by the declaration. So make sure that you're not just relying on that, oh, well, we have the ability to control literally anything because the architectural committee doesn't like it for aesthetic reasons only. Yes, that might be enforceable, but the better way to do it, in my opinion, is to make sure you've got established architectural standards and everyone knows if I want to put up my shed, here's what it needs to look like. Here's the materials I need to use, the colors I need to use. Does it need to match the residents on the property? Does it need to be in a certain location, etc.? So you're going to want to make sure you've got these standards and that they're published to the community, meaning that everyone actually knows they exist, not just, well, we had a board resolution and we put it in the official records and it's on them if they don't know about it. If you put it in the public records, then everyone's on notice. And that includes people that don't reside in the community or don't own in the community. But if all you have is a board resolution, that's not good enough to place the members on notice of what's required of them. Okay. Another change in the Florida statutes last year pertains to deposits. If you collect a deposit from a member, and this is generally going to be, you've got construction going on, you've got a tenant going in, those funds can't be commingled with any other association funds. You also need to return the deposit within 30 days after notice that the construction project or the tenancy or whatever it is has terminated. And if a request is made as compared to any other official records of the association, you only have 7 days after receiving that request to provide an accounting for this particular type of deposit and how interest accrued, how you used it, where did the money go? Okay, so just understand this is different from what we're about to talk about with respect to official records. This is a very specific type of official record. Okay, moving along, and yes, deposits for auditorium rentals will be included. And I'm going to go ahead and stop, no offense to anyone, but looking at the Q&A, because we do have, we're on slide 23 of 188, and we're almost at noon already. So I'm going to blitz through the rest. Right to official records. It's a right that the members have. It's policy number 4 that I recommend every community have is how, when, and what will it cost to have a member inspect the official records? What needs to go into the request, etc. The association has to basically keep every piece of paper, every document that pertains to the operation of the community. I won't go into detail about what records need to be maintained, but it is important to note that there are certain records that can be removed from the official records and are no longer subject to disclosure to the members. One example is listed here because the statute changed last year, as I mentioned. If you pull your email address out and you're no longer getting official notices of the association to that email address, if you change your mailing address, those old mailing addresses, old email addresses are no longer subject to inspection by the members. It's only the new one. If you opted out of email notices completely, then no email address for your particular property is going to be provided to the members. Now, there is a distinction here that I see coming up fairly frequently. If you provide an email address so that you get the little newsletter that goes out from the management office once a month, that is not the same as providing an opt-in email address for official notices of the association. So if you didn't opt in to get your notices of the annual meeting, all of the board meetings, etc., electronically, that email address that you provided just so that the manager can reach out to you is not an official record of the association. So again, we talk about what goes into these official records. Okay, again, look at the last bullet here. This is why I'm not bothering. Okay, all other written records of the association that are not specifically identified in the Florida statutes, which are related to the operation of the association. Again, every document pertaining to operation of the association goes in here. Now, there is a question of whether emails between directors and management that have not been converted to an electronic saved record outside of those email accounts are official records. My answer is, if you want to be safe, treat it as though they are. There are DBPR decisions that have been made that say those are official records. But the DBPR changes its mind every other opinion that it provides, in my experience. So there's not a ton of consistency there. There is not any precedent that specifies that you absolutely must treat that as an official record of the association. But out of caution, I would suggest that that be something that you do. Anytime that there's an email that goes out from an association director or from the manager, that gets saved in the official records. Another suggestion that I will make to every director that's not already doing it, create a separate email account for association business that's not your personal email. And that is partially because then, instead of providing your email account, your personal emails, and having to go through all that crap, you don't want to have to go through emails with your kids, your parents, your cousins to look for records that pertain to the operation of this association when you're asked to do so, either in an official records request or in discovery in a lawsuit. You want to be able to access that stuff easily. You also don't want it to be accessible by anyone other than the association's attorney, whereas some of that information might be discoverable otherwise. Okay, so make sure that you've got, even if it's just a director at HOA.com, like director at WaterlyHOA.com. I've got some that will actually hand down that email address from director to director, because what they do is actually make it president at WaterlyHOA.com. Okay, so that makes it easier. You're actually sharing literally all of the information that you've ever been emailed back and forth just by trading the credentials to log into that account. It's something that I suggest doing. So I'm not going to get into the specific records that you need to maintain because it's basically everything. Now, there's a distinction between what you need to maintain and what you need to produce to the members upon request. We'll get into that in a minute. Unless it's otherwise stated in the statute, because there are a couple distinctions here, every official record must be maintained for at least 7 years. My recommendation, never get rid of them, because if you go to condo land, almost everything needs to be kept from the inception of the community. So, and that was a fairly recent change. It used to be the same 7 years. You want to make sure that you're not basically putting yourself in a position that you're going to violate this restriction, this statute. Just keep everything. Unless you've got a specific set of criteria for how and when you destroy those records or delete them, which I guess is another policy that I don't necessarily recommend you have, because I'm telling you, keep them. But if you're going to have any destruction of records, make sure it's pursuant to a policy that has been adopted by the board and complies with the then existing Florida statutes and will be adapted to comply with future changes to the statutes that say you need to keep these records even longer. Let's see, we talked about what goes into the official records, so I won't go through that. Again, we have records that are not accessible to the members. I'll breeze through these because I think it's important enough to talk about it. Anything that is privileged, that is attorney-client privilege or work product privilege, is not subject to inspection. Now, some people will say that that's until the proceedings are completed. My argument is that's BS, because the bottom line is someone can dismiss their case, get the documents, and reopen the case 6 months later, or file a new lawsuit about the same exact issues. I'm dealing with round 3 of a lawsuit that's the exact same issues right now because the first case was dismissed. Well, at that point, there's no pending litigation. You don't know of a threat that that case is going to be refiled, but that doesn't mean it won't be. So my perspective is that attorney-client privilege, that work product privilege, doesn't go away just because that case is dismissed or there's a judgment entered. That can be appealed. It can be overturned later. I mean, there are situations where a 5-year-old judgment is void and you've now disclosed all those records. So my perspective is that never changes. That privilege extends until the board decides, not an individual director, but the board or a judge decides that that privilege needs to be broken. There are other things in here. I'm not going to go through them in detail because frankly, we don't have the time, but the good news is if you inadvertently disclose any of this information that you're not supposed to provide, that's kind of a no harm, no foul. If it was inadvertent, the directors are not held responsible and the manager's not held responsible for giving that information out that's supposed to be held confidential. That said, be really careful about not giving it out because this is all to protect your members and protect the association that the statutes say you don't have to produce this information. Let's see. We talked about this, talked about privilege and membership directories. You do need to have an association roster as part of the records you're maintaining. So make sure that you're actually doing that. It should be kept in a manner that is producible. But if it's kept digitally, all you really need to do is provide the opportunity to inspect it. If the member wants a copy, keep in mind when you're producing these records, you produce what exists. So let's move on to production because that's the next slide anyway. You have to make, when an owner requests a copy of these records, you have to make them available for inspection and copying. Not here are the records, they're yours now, but to inspect, to physically look at them and copy them within 10 business days after receipt of a written request for access to the records, within 45 miles of the community or within the community. So when I have a client whose management firm only has offices that are 100 miles away from the community, that's not a place that you can hold that records inspection within the management office. It has to be within 45 miles or within the county itself. Now, the request must be submitted by certified mail return receipt requested. There is a rebuttable presumption that arises if that, request is submitted that way and the records are not produced within 10 business days after the association gets that request. What this means is that the courts are going to presume, that's what the rebuttable presumption is, the court will presume that you intentionally failed to produce the records. Now, if you had a flood, if there was a hurricane during the pandemic, there were certain reasons that could rebut that presumption. You could defeat the presumption, but the burden is going to be on the association to prove that you didn't do this intentionally if this is what happens. Now, you can have a copy available for inspection in the community electronically via the internet. I see a lot of communities simply directing people to their website with login credentials so that they can just access the records. That's fine as of right now. Or you can say, well, you can view them on a computer that's sitting in the management office or in the office, the clubhouse, whatever you've got in your community, and print it upon request. Cherry picking of records is also not required. The association doesn't have to say, you asked for these 10 documents, here they are. You can literally have boxes and boxes of crap that you bring into this office and say, you asked for these 10 documents. We think they're in here. Have at it. Have a look. If you find them and you want copies, you can make electronic copies for free by scanning it with your phone, your tablet, your camera, whatever. If you want us to make copies, there will be a charge. So this is, again, one of those policies that I think you should have, stating exactly how much those copies will cost. Okay, keep in mind, if you don't comply with the request by producing these records in the time that's provided in the statute, those 10 business days, then the next day thereafter and every business day after that, you're going to incur a $50 fine that you owe this owner, up to $500. I call that the $500 gift, and it's not one you want to give. Keep in mind, on top of that $500, the owner's then entitled to their attorney's fees and costs if they try and pursue that against the association, that failure to produce the records. Okay, so basically, don't screw it up is really what I'm saying. It's very easy to produce the records within 10 business days. If they don't exist, just say none exist, and then you don't have to produce anything. Again, you're not creating records. You're just saying, here's what we've got. We talked about rules. That's the policy that I mentioned. Be specific in this policy. Don't say, well, once a month you can inspect the records, and not more frequently than once a month. Because then you end up with people that are requesting it on the 30th and again on the 1st. Say every 30 days. You want to be clear how people are allowed to request the records, how they're allowed to be produced, and how they get copies. You can limit it to you can't limit it to less than 1 8-hour business day per month. That doesn't mean you can't split it into 4 independent sessions of 2 hours. And I do have a community that's dealing with that situation right now. My opinion is that's totally fine, because the person works nights and they're providing 2 hours a day until the inspection is done. As long as you're not saying you get 2 hours and then you're done, good luck. That doesn't work. The owner doesn't have to show a purpose for which they are requesting this inspection. It's just, hey, I want to see the documents, I'm entitled to them. That's it. Okay, so don't sit here thinking, well, I think they're going to use this for a bad purpose, so I'm not going to produce it. You can make the business decision to take the risk that they will sue you. It's generally not going to be a good business decision to make, but I guess that's within the board's discretion. Fees can be up to 25 cents a page made on an association photocopier. If you don't have that photocopier and you're going to produce the records by getting it done at Kinko's or something similar, you can charge the actual cost of duplicating the records. That, generally speaking, is going to be something, in my experience, that you tell them what it's going to cost to make the copies, you have them pay it, you produce the copies, not in the other direction where you pay the $100 that it costs to make all the copies they want and hope that they come pick it up and pay for it. The other thing, the association can charge for personnel costs to retrieve and copy those records. If the time spent exceeds a half hour, meaning that the actual inspection and the copying takes more than a half hour for the manager or whoever it may be, and that person is charging the association for their time, up to $20 per hour. I can almost promise you that management's cost and charge to the association will be more than that. So understand, it's not whatever the association pays for that cost. It's up to $20 an hour. Oops. All right. Let's see. You must allow someone to scan the records in if they have a scanner, a cell phone, a tablet, whatever it may be, at no charge. We talked about what happens if you don't provide it in time, and now we get to move on to elections. Okay, the good thing about association elections is the answer is in your bylaws. That's pretty much the entire section of this presentation. You just look at your bylaws. If your bylaws are silent on an issue, then you look to chapter 720, and specifically 720.306. Your election is going to be governed by that provision that generally governs your bylaws, and subsection 9 talks about the elections. So to avoid disputes, this is just a pro tip, to avoid disputes over the validity of the election, which would mean that you have to hold another election and pay the money to have another election, make sure that you eliminate nominations at the meeting, and that if you're going to do that elimination, meaning you're telling people you can't be on the ballot, that the documents don't allow them to be on the board. Generally speaking, you don't have to be a member of the association in order to be on the board, unless your governing documents restrict that issue. Make sure to formally close the balloting also at some point so that you're actually able to count the ballots and have an election result. Usually it's going to be somewhere between 10 and 15 minutes after the meeting starts. And unless you know that people are not showing up, Some people will stop that like 5 minutes after the meeting starts because they don't want to reach a quorum and they want to make it easier to just go home. I'm okay with that, to be candid. If people can't show up on time, maybe their ballot doesn't get submitted because they didn't choose to mail it in advance. When you allow nominations from the floor, that might not be an option because you don't know who's going to nominate themselves from the floor to that election meeting. Meaning, people step up at the meeting and say, I'll volunteer. If that's something you're allowed to do, which is going to be in your bylaws, then generally speaking, you can't really have an advanced ballot. So just understand that issue as well, that you might need to kind of create the ballot on the fly or just leave blanks in your ballot so that the people that nominated themselves in advance of the meeting are listed and typed in, and the people that show up and announce that they're interested as well at the meeting are added in. Keep in mind, you're only allowed to do those nominations from the floor if it says so in your bylaws. Let's see. So you need a quorum unless the bylaws say you don't. If you don't have an election, like I said, if you don't have that quorum, and people didn't put their votes in via proxies, you're going to hold over. The directors are going to have one more year that they all stay on. There's nothing wrong. So I do often hear, oh, well, they haven't had an election in the last 5 years, so everything that this board did in those 5 years is completely invalid. No, it doesn't work that way. Okay, if the people didn't care enough to show up at the election meeting, you don't need to hold an election. And in fact, you can't hold an election. You do need 14 days notice before you actually have that election meeting. Keep in mind, most people are going to be eligible as candidates for the board unless one of these things that's listed in the slide here applies. It's basically people that are delinquent in the payment of any monetary obligation to the association on the last day you can nominate yourself. That'll usually be the date of the election because you can nominate yourself from the floor. If there's another date, it'll be based on that particular date. If you've been convicted of a felony and you haven't been out of prison for at least 5 years on the date that you seek election to the board, you're not eligible. If you have pending criminal charges for felony theft or embezzlement offenses involving association funds or property, you can't be on the board. You have a 1-year term unless your bylaws say otherwise. Basically, you have a re-election, so to speak, every single year. Talked about nominations from the floor. So keep in mind, election by acclamation is sometimes a great thing. If you only have 5 open director slots and only 5 people have put their names in the hat, you don't have an election. You have 5 directors. If you have 4 people that put their name in the hat, same deal. If you have 7 people that put their name in the hat, now you need an election. If you have 7 people that put their name in the hat, but they're the only 7 that showed up and you needed 20 to actually have a meeting, sorry, but the people that were previously on the board are still on. I hope that kind of delineation clarifies what we're talking about here. Members have the right to vote in person or by proxy unless the governing documents say otherwise. Generally, whoever gets the most votes wins, and that's it. Moving forward, election challenges have to be raised within 60 days after the election. You also can't raise an election challenge within 60 days before an election. Same thing applies with recalls. You can't do that 60 days before or after an election because, frankly, it's a waste of time. You're going to have an election or you just had one. You would basically either deal with that issue of not liking the director who's on the board or what they're doing or wanting someone else on the board. You'd either deal with that by voting differently at the upcoming election, or if the election just passed, challenging the election result for some reason. Once that 60 days passed, then you can go through the recall process. Any dispute between a member and association does go to the division for binding arbitration, or another option now is you go straight to court about that election dispute. And that, frankly, is where I'd recommend you go. Anytime you can avoid arbitration with DBPR, they have some fantastic arbitrators, but some of the ones that were frankly the best have left in recent years. And again, their decisions are just inconsistent. And I would much rather walk into court knowing that precedent is going to be followed. And if my client did the right thing, they should win. It's never guaranteed, but if the proper procedures were followed, realistically, there's no reason you should lose in either venue, but you're less likely to lose, in my opinion, when you did nothing wrong in a court. Electronic voting we talked about. Really all it requires is use of a good vendor that can comply with the requirements of the statute and a board resolution that was adopted at least 14 days with at least 14 days notice in advance of the meeting. keep in mind, just because you've adopted electronic voting doesn't mean everyone is going to vote that way. It's only the people that actually opt into electronic voting that can or must vote in that manner. And when I say must, you really don't have that obligation. You can still submit a paper ballot if you're able to get your hands on one. Let's see. Election of officers, generally speaking, you're going to have first your election. If you don't have your election, you don't have a meeting. But if you have your election, then the people that were elected during that annual meeting are then immediately after or in conjunction with that meeting going to hold what's called an organizational meeting. That's where the directors who were elected decide among them, or if your governing documents say that you don't have to be a director, that's great. Make sure that they select among those people who are the officers going to be, the president, the vice president, the secretary, and the treasurer. Okay, that's all going to be decided right after the election meeting. Now, here's an important question that we haven't talked about. Does the president get to vote on board issues? And the answer is absolutely not. The reason for that is that the president is an officer position. That president may also be a director, and the directors get to vote on board issues, but the president only votes as a member of the association at member meetings. Okay, so just understand there are 3 different hats you might be wearing here today, unless you're a CAM that's here just for credit. Okay, if you are a director of an association, chances are you are 1, a member of the community. That's someone that owns property in the association. That's all it is. Okay, it's a member is someone who owns a lot or a parcel. Now, there are different distinctions. Some communities have commercial property located within a master, etc. So I'm not getting into the details of that stuff, but generally speaking, the members are the people that own property in the community. The directors are the people that get to vote on board issues. They make motions, they second motions, they abstain from voting, they vote. They discuss motions. Those are literally the only things directors do. They're very important, don't get me wrong, but those are basically the only 5 tasks a director will perform. Then you've got your officers. Those are the people that have specific tasks. Your president is generally going to be the mouthpiece of the association. You've got the vice president that gets to do pretty much nothing other than probably also serve as a director. You've got your secretary who keeps the records, and you've got your treasurer who keeps the funds. And if you've got a property manager that's doing their job, most of those positions don't actually require you to do much of anything other than serve as a director. Okay, but those are 3 separate concepts. So when someone says the president of the board or the board president, that's a position that doesn't exist. All right, now that we're done with the semantics, let's move forward. There was a change in the statutes regarding fraudulent voting activities. Basically, you can't forge ballots. You can't push people to vote in one way, or when I say push, I mean force with threats or any other bribes or things like that. To vote in a certain way. You can't prevent members from voting. All of these things that are listed in these slides will be considered tampering with the election and will get you off the board and potentially subject to criminal penalties, which we really try to avoid. Getting into the board of directors, we talked about the different hats you might wear. The most important thing about being a director, the most important thing you will learn today is your fiduciary duty to the association. That fiduciary duty is a responsibility to do what's in the best interest of your association, the business that you're running, even if it's against your own best interest. You have a responsibility that is the highest duty imposed by Florida law. It's like basically you're a trustee of the association. You can't be tasked with a higher duty. Okay, the good news is you're also judged by the dumbest person in the room standard in enforcing that duty. And what I mean by that is you are not held liable for any actions you took as a director under Florida law unless a reasonably prudent person would not have reasonably thought that those actions were in the best interest of the association. Okay, so if you can justify any business reason for doing what you did, there is an actual rule called the business judgment rule that will protect your decisions as a director. Other good news, you've probably got an indemnification provision in your governing documents that'll also protect you, where the association provides your defense if you're sued individually as a director. And when I say you'll be sued or can be sued individually as a director, understand, I can sue you for running in the wrong direction when you're 5 miles away from me. Having a lawsuit filed doesn't mean you did anything wrong. It means someone had the money to pay a filing fee. Okay, so don't sit here thinking, oh my God, I'm going to get sued. I'm going to pay millions of dollars, blah, 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 blah. No. That's why you check for an indemnity clause in your governing documents. If it's not there, you make sure that you amend it into your governing documents, whether that requires a member vote or not. And you pay the third most important bill you will ever pay for your association. And that's going to be your directors and officers liability insurance policy. That's the insurance policy that covers you as a director for doing things that directors and officers are supposed to do. Okay, you're representing the association. You're acting on behalf of the association. That's literally your job, whether it's a volunteer job or not. It's your job as a director or an officer. Now, I mentioned that's the third most important. Your manager's probably most important. My bill's second. Keep in mind, like I said earlier, the board makes almost every decision for the association. The members make very few decisions other than who's on the board, okay? Unless the ability has been delegated to make decisions. No individual director and no individual officer should be making decisions, acting on behalf of the association, or doing literally anything that hasn't been authorized by the entire board without that authority, period. Okay, I have lots of rogue directors. Keep in mind, the officers serve at the pleasure of the board. What that means is when your president is doing whatever the hell they want and the other directors are fed up with it, you put on the agenda that there is going to be a vote to remove the president as president and have them either in a lesser position, so to speak, or no officer position, and put someone else in that president role who will follow the rules. Now, that is yet another one of the policies that I recommend having that every community in Florida should have, is a board activity or a board behavior policy. I think that's crucial so that everyone knows what's expected of them as a director. Not just the law, but what behavior is going to be tolerated and what's not. And violation of that behavior policy is going to be a violation of the governing documents that's going to be enforceable just like every other covenant of the association. Because keep in mind, regardless of what's in your bylaws, this firm's opinion is you can't just pull someone off the board because they're doing wrong, because they're not showing up at meetings, etc. You can have them recalled and removed. You can have everyone vote against them in the next election. But otherwise, you're stuck with them until that election happens or until someone else is voted in. So treat it as though, I mean, one thing that I've seen happen is that is a finable offense. You fine them, and if they don't pay the fine, then they eventually get pulled off the board, because 90 days after an account goes delinquent, regardless of the nature of the charge, if it's not paid in that fee, fine, or other monetary obligation is the language the statute uses, if that goes delinquent, it's not paid to the association after it's been levied and the owner's been notified, then that director is automatically deemed to have abandoned their seat on the board. So this is another way you can get them off, is to essentially adopt that policy, fine them for the bad behavior, and if they continue the behavior, you fine them again. If they don't stop the behavior, then they are technically off the board if they don't pay that fine. The board's generally responsible for the maintenance of association property as well. So you do have health, safety, and welfare powers of the board. All right, come on, there you go. Directors cannot vote by secret ballot or proxy unless it's to elect the actual officers during that initial meeting. So you're going to have open votes. Now, that's become a major issue as well. The open voting doesn't mean that every single discussion is had and every piece of investigation is had during a board meeting. My opinion, that is not shared by all attorneys, including all attorneys of this firm, is that the board is allowed to investigate and get information, including meeting with vendors, as long as no business will be conducted, meaning from my perspective, no vote will be taken. So you've actively decided we are not voting on this issue today. We will vote on it separate and apart from this meeting. At that point, from my personal legal opinion, that's not a board meeting and it doesn't require openness or a notice to the members. As soon as you're going to make that decision, you need a notice, you need it to be open to the members. Now, when we say no voting by proxy or secret ballot, that does not preclude the association from making decisions that are later ratified, meaning that at the next board meeting, you act as though you didn't make the decision, even though it's been made and you're acting on it already. You have the full discussion, you have the vote, and you formally adopt what you've already decided. Or the alternative, if the decision is unanimous and your bylaws and articles of incorporation don't say you can't do this, Chapter 617 actually authorizes an association to adopt a written resolution that is unanimously passed by all of the directors and fully replaces a board meeting. Okay, so those are other options. Now, meetings of the board can be closed, like I said earlier, if you're talking about attorney-client privileged information, meaning potential or ongoing litigation, or you're talking about employee issues. Now, that doesn't mean the employees of your management firm. Doesn't mean you're changing the manager, unless that manager is directly employed and paid directly by the association. Okay, so that is a distinction that I need to make because I see a lot of people make that mistake. You can use email as a means of communication. You just can't vote via email as a director. Again, no unilateral decisions. We talked about fiduciary duty, and it's okay not to be right as a director as long as you had a reasonable belief that what you were doing is in the best interest of the association. That doesn't mean you won't be sued. It means you shouldn't lose that lawsuit for breach of fiduciary duty. The association might still lose the lawsuit for making the wrong decision, but you personally as a director and officer should still prevail in that lawsuit. We talked about agendas for all board meeting notices. Let's see, 48 hours is the only notice required for a board meeting, unless you are talking about adopting use restrictions, meaning changing your architectural criteria, rules and regulations, etc., or you are adopting an amendment. Or finally, you are talking about a special assessment. All of those latter items will require a 14-day notice, not just the 48 hours notice. Now, that 48-hour notice needs to be posted in a conspicuous location in the community, etc. But that's just the basics. You don't necessarily need to mail notice of every board meeting. You can have literally a stick in the ground with cardboard on it and marker stating this is the date, time, and location of the upcoming board meeting. You don't even need to say you're allowed to appear because that's automatic. Okay? It literally is board meeting of whatever community you're in, date, time, location on cardboard. That's good enough. Okay. You can put that notice on the website or an app if the members have opted in for that, instead of posting the notice in a physical location. My recommendation, just post it on your website and a physical location if you have a website. That way you don't have to worry about whether an owner is going to complain that you're not complying with their personal preference. It doesn't take that much. Like I said, it's a paint stirrer and cardboard and a marker. And the marker you can use for about 100 of those notices before it runs out. So what's it going to cost you? $5 to put up that notice? Just do it. It's simple. And then you don't have to worry about it. Directors can't directly receive any compensation except for participation and as a financial benefit that all the members get. Reimbursement for out-of-pocket expenses pertaining to the association, which is another procedure you should have in writing, not necessarily a policy, but a procedure that is required in order for those reimbursements to happen to protect your association. Recovery of insurance proceeds that a policy was covered by the association for its members, or any compensation authorized in the governing documents, or a majority vote of the voting interest present and voting at a board meeting. Or I'm sorry, a member meeting. Keep in mind, we do have kickbacks and conflicts as an issue. Okay, so that's what we're talking about here when it comes to what I just said about compensation. We're talking about kickbacks. Kickbacks are illegal. In condo land, it's actually a criminal penalty. Here, you'll likely just be off the board and potentially sued to get back whatever the kickback was. I say just, that's not a just. That's a really bad black mark on your record if you ever want to serve on a community association board again. An officer and director, you can't take kickbacks, which is a benefit that you get for suggesting or using a specific vendor for your association that not everyone in the community gets. But you can accept food to be consumed at a business meeting. with a value of less than $25, which is why we're not taking you out to Roots Chris if we meet up. We might be going to Ale House. And I'm allowed to pay for that at a business meeting with a director, with a manager. What I can't do is pay for that more expensive meeting. The other thing, you can get a service or a good received in connection with a trade fair or an education program, meaning we can have a raffle that you win, and that is not a benefit that you got by virtue of being a director. Or if we give away our little swag, our pens and notepads and things of that nature, that's okay. You're allowed to take it because it's part of a trade fair or an education program. And when we do trade fairs, usually we're providing both. We've got the upcoming Orlando Condo and HOA Expo where we'll be teaching 2 classes. That's the type of place where you'll be allowed to take those types of items and you don't have to feel like, oh my God, I have to disclose this to all my members. Immediate removal of a director or officer is going to happen if you forge ballot envelopes, which we discussed earlier, you steal money from the association or property from the association, which is a crime in and of itself. You destroy association records or refuse to produce them in connection with another crime that you are performing. Obstruction of justice, again, also a crime. Now, there are changes that came into place last year regarding conflicts with directors. You need to provide at least 14 days notice of the conflict and the contract or the service that's going to be performed that you have a conflict for at least 14 days in advance of the board meeting. So that's a change in the statute, that this is another 14-day notice if there's a conflict. There is a rebuttable presumption of a conflict if a director, officer, or relative, or that person individually enters into a contract for goods or services with the association or holds an interest in a corporation or a business that proposes to enter a contract with the association. When you have these conflicts, understand we've got a separate class on this, so I don't have the time to go through it in detail. But generally speaking, you need a supermajority vote of the other directors, and this individual who has a conflict can propose the conflicted contract or service, but can't participate in the voting or discussion by the board on it. They're allowed to attend just like every other member, but because of the risk of basically intimidation, they have to walk out of the room entirely when the board is discussing and voting. Let's see. If there is a contract with a conflict, and we do go through some of what I just said, that supermajority is 2/3. If that contract is entered, then at the next member meeting, whenever that might be held, it could be 6 months later, the members are allowed to make a motion and vote to cancel that contract. If the members do cancel that contract because the conflict wasn't disclosed, the only thing the association is responsible for is the work that was done or the services performed or the value of the goods provided through the date of cancellation, even if there's a termination clause that says otherwise in the agreement. So just understand the members do have that ability. It's not something we talk about frequently, but it is something that is useful. Basically, if you're charged by information or indictment, these are criminal law terms. Basically, if you're charged with a felony theft or embezzlement offense involving association funds or property, you're out. The vacancy is removed by the board by usually that's going to be by just a board vote rather than a separate election process. That is going to be until the end of the director's term or when that director is no longer suspended because the charges are resolved without a finding of guilt or acceptance of a plea of guilty. You must reinstate that director after their criminal charges are dismissed or whatever happens. If that criminal charge goes through, trust me, you're not having them back on the board because they stole money from the association. If those charges are pending, you can't be appointed or elected to a position as a director or officer. Not telling you to go out and report people who did not steal things just to keep them off the board. Please do not do that. And I'm not saying that facetiously, although sometimes I do stuff like that. I'll say, oh, please don't do it. No, I mean it. Do not report a criminal violation that never happened. You're going to get yourself in trouble, not get the other person in trouble. We talked about the excessive gifts. If you find that someone got one of these kickbacks, these additional benefits, beyond the $25 in food or beyond the service with trade fairs or educational programs, that person's also off the board. Vacancies created by the expiration of a term or filled by an election. Vacancies created for pretty much any other reason other than a recall or filled by vote of majority of the directors. That's called an appointment. Super simple. And that appointment is for the remaining term that's left where the director who vacated their position would have served. So if you have a 3-year term and you're only 6 months into it, that person who gets appointed is going to serve for 2.5 years, not until the end of this coming year. Again, just like members can participate in regular meetings of the association, they can also participate in board meetings. Same thing, same policy. The only distinction is that they don't have the right to vote at those meetings, and the board gets to control when the members get to speak during those meetings, not just how long they get to speak. We talked about recording. Any member is allowed to record a board meeting, just like a member meeting. Again, just like a member meeting, you got to provide that handicap access to someone who actually has a right to attend the meeting, actually has a disability, and has a disability that will be served by the method that they're asking to attend. We just had a complaint by someone who wanted to attend by Zoom with specific qualifications of the quality of the Zoom. That was dismissed, but they had the right to attend the meeting. They just didn't want to drive. They didn't have a handicap, but the association didn't have time to do that investigation. We might have discovered that, we might not have. So just be careful when someone mentions disability. If you don't have that policy in place that tells you how to react immediately, when you hear the word disability, handicap, blind, deaf, assistance animal, any of that, it goes to your attorney, in my opinion. You can have committees adopted by the association. The board basically can say, hey, we're creating this committee to make our job easier. Not a problem. You can have advisory committees. You're generally going to have an ARC committee. That's the architectural committee. If you've got the right to restrict architectural modifications to property, there are a couple others that we'll go through in a little bit. That include fining and use right suspensions, voting suspensions, organizing committees for covenant revitalization, if your covenants expire, etc. We talked about conflict of interest. There's also required disclosure for the developer appointed directors when you have a pre-turnover community. And that disclosure is really nothing more than once a year they need to tell everyone that they were appointed by the director. That's pretty much it. That doesn't create, the fact that they were appointed by the director doesn't create a conflict of interest. Okay? There may be a conflict, but it's not an automatic, it's not a presumed conflict. We talked about what is and is not a meeting of the board, in my opinion. And again, not everyone's going to agree. I have a lot of attorneys tell me that anytime that a quorum of the board meets and even remotely starts discussing association business, that's a board meeting. I don't agree, but I do agree to the extent that a judge could possibly find that. I wouldn't agree with that judge. I would be suggesting that a client appeal that decision, because a board meeting occurs whenever a quorum of directors is together and conducts association business. To me, it's not conducting business until you do business. And just having a discussion, to me, is not conducting that business. To a lot of attorneys, it is. So you'll want to get a written opinion from your particular attorney as to whether or not they believe that this is an issue or not, to have a separate meeting that isn't a board meeting, in my perspective. Okay, I'm not going to go into too much detail about that because it's really a legal opinion, but keep in mind that same openness and notice requirement applies to committees if the meeting includes a vote on whether to spend association funds or is an architectural review decision. So they also have to provide notice of their meetings to the members, or at least the member that might be impacted by it, and also give the members the opportunity to attend and speak at those meetings. How to get off the board. Recall, basically the members vote you off. Failure to have your certificate from a class like this or the piece of garbage that you signed. Criminal charges we talked about, excessive gift we talked about, resign in writing voluntarily. I can't do this crap anymore. There's too much going on and I can't deal with it. Yeah, that happens. I get it. You're a volunteer that's not being paid to be berated fairly frequently by people that have no idea what they're talking about. I wouldn't want to do it either if I wasn't getting paid for this. That's why I'm not on my HOA's board. I understand. At least it's one reason I'm not on board. And then becoming 90 days delinquent in the payment of any monetary obligation, we also talked about. The other way you can get off the board is if you die, you can't really serve. I've seen people try and keep the dead person on the board. Usually doesn't work well other than in Weekend at Bernie's. We won't go through these because we kind of already did. Minutes. I want you to understand. Meeting minutes are not a verbatim quote of everything discussed at the meeting. It's here's the motion that was made. Here's how everyone voted on it among the directors. Here's who abstained. That's it. Those 3 items are all that needs to go in your meeting minutes. We open the meeting. The presiding officer was the president who opened the meeting at this time. That's the entire first item on the agenda. That's your minutes. When you have an actual vote, again, this is the motion that was made, and I skipped one that I'll add, I apologize. Here's who seconded that motion so that it can be voted upon. Here's how each director who attended the meeting voted. And here's a list of who abstained due to conflict and stated the reason that they believe they have a conflict. I also want you to understand that you can't just say, well, I don't agree with what the board is doing, so I'm not going to vote on this. That's not an abstention. And disagreement is not a conflict of interest. A conflict is where you have a personal interest in the outcome of this. We talked about that earlier. Okay, so you're not just not voting. And by the way, if you don't like what they're doing and you don't vote, you've basically said, that's fine. I basically vote yes without voting. That's the equivalent of what you're doing. Put in your vote. If you disagree with what the board's doing, say no. Have the guts to actually voice your opinion. That's why you got on the board. And if you're not willing to vote on issues you don't like, you should probably step down and let someone else step in. Let's see, moving forward. The association may or may not have access to the individual lots. If you have a right to access, you might need to also give notice before you step onto someone's property and either try and perform self-help, meaning you cure a violation on the property, or you do whatever you need to do in easements and things like that. Just understand, you don't have that right unless your governing documents or some other recorded documents say you do. So there's got to be some agreement between the owner of that lot and the association to authorize you to step onto that property. You're not in a condo where there's a statutory right of entry. So just understand, in an HOA, unless your governing documents say you cannot enter that property. Okay, moving along. Material alterations. In a condo, again, big issue. In an HOA, unless your governing documents say that you need authority from the members to change the visual aspect of an item in the community, meaning your clubhouse is being changed from a light yellow color to pink. Okay, unless your members have the right to vote on that issue pursuant to your governing documents, you can do whatever the heck you want. Now, the other way that I see that controlled in an HOA context is a dollar figure that if you are going to spend more than $5,000 on any item of maintenance or any changes to the community, the members get to vote on it. My suggestion, up that to 15, 20 grand. But in the interim, that's where you're going to see if you're changing what something looks like outside of a lot, the association might or might not need to get the approval of the members. The owners, same deal. You might or might not need to get the approval of the members based on whether or not you have an architectural approval provision in your governing documents. Generally, you don't have to get that approval from the members to change the visible appearance of any of those things in your community. Okay, there is case law that also would say if you are making those changes, and the members generally have the ability to control that, meaning they get to vote yay or nay. Understand that if you're doing it to protect the association, meaning it's more protective than what was there before, or you're making those modifications to add protections. Generally speaking, even though your governing documents say you do, you don't have to go back to the members. But that's when you'll want to get your attorney's opinion on. Just don't presume without going to the attorney that you're going to need that member vote, because you might be able to avoid it and save a bunch of money and a bunch of time. We talked about amending the governing documents. Generally speaking, you're going to need a 2/3 vote of the members not just 2/3 of the people that show up, in order to adopt an amendment to your governing documents. Now, again, very popular amendment is changing that proportion to a majority of a quorum, meaning you need to get your quorum to show up, which you can also reduce. You can go from 30% quorum to 10% of the membership showing up in order to hold a meeting, and make it 2/3 of the people that show up, or a majority of the people that show up. Make it easier to make changes to your governing documents. Now, that's a double-edged sword. It could be beneficial, or it could mean that every time you have a new board that doesn't like what's going on in the community, you have another amendment to your governing documents. There is a specific format that you need to go through. There are lender consent issues that were addressed in the statutes over a decade ago, where your governing documents say you need to get the lender's consent unless it directly impacts the lender what you're changing. For example, I just had one that adopted statutory safe harbor after a lender forecloses. That type of thing where it's going to directly impact what a lender owes or a purchaser at a foreclosure sale owes. Once that foreclosure sale is done, that's going to impact the lender, and the lender gets to vote on it. Okay. But if it doesn't impact the lender, if it's, we want to allow people to paint their houses without architectural approval, so what? Lender doesn't care about that. You're going to give them 60 days, what we call negative notice, and let them know, hey, this amendment is being adopted. If you don't tell us you don't want it, we're going to move forward with it. And then the lender gets to voice their objection. If they don't within those 60 days, you move forward. If they do, there's a process you need to go through to get the amendment passed anyway. Developers can't exercise unilateral power of amendment if the amendment would alter the general plan of development. Another pro tip, if you are in a community that is pre-turnover, that's going to be the easiest time to get these amendments adopted, because most developers will leave a carve-out in their documents where they get to unilaterally make those amendments. So if there's something you think will be beneficial to the association, but it's not in there now, run it by the developer and see, even if it's a week before the turnover meeting where the members get to elect all of the board members, they might be willing to adopt that amendment so that you don't have to get a vote of all of the members. It's just a decision of the board, basically, that the developer will adopt it. Let's see, we talked about, you do need to provide copies to the members. There are a couple different ways you can do that we don't have time to go through, but we do have a whole class on amendments. So again, I would suggest you check that out. I got to kind of skip through some of this stuff. I talked about rentals, leasing restrictions. There is an entire class on that issue in particular. We talked about rules and regulations, whether they're enforceable or not. They technically don't need to be recorded. If they are recorded, then everyone's on notice of what's in them. And if they are recorded, just keep in mind also that if you ever want to change those rules and regulations, the architectural criteria, whatever it may be, those board adopted rules and procedures, you need to also amend the revisions, the amendments to those rules and regulations before those amendments will actually take effect. Pardon me, because something that everyone is on notice of is going to take precedence over something that not everyone knows about. Okay, rule adoption. The procedure is basically, again, you give 14 days notice that the board intends to adopt this rule that changes the use of a parcel or a lot, and then the board gets to go ahead and adopt it. Now, if you are adopting procedures that don't impact the use of the lot, for example, the covenant enforcement procedure I mentioned earlier. Another one I mentioned everyone have is a collection procedure. Okay, that policy is not changing what's in your governing documents. It's not changing how you use the property. It's not changing how you use the common areas. That doesn't require a 14-day notice. It's a 48-hour notice. It's just a board meeting. But you do have to send notice out to everyone that the policy was adopted and either have a copy of it given or let them know where they can request a copy in order to get it. Okay, I'm going to take a quick sip here. The Market on Record Title Act is another thing that merits its own class, but I don't think we have one on it yet. But it's essentially a law that says 30 years from what's called a root of title. Most attorneys will say that that's your declaration because it's easier to calculate rather than going through what the reality is, the date that every single deed separately was delivered from the developer to the individual homeowner for that particular lot. And the reason that I say it's easier is you don't have to look up the county records for every single lot in your community. We've got communities that we represent that are 3,000 or more lots. that would take a really long time to figure out when that was recorded. So what you can do is preserve your covenants by recording something that's literally a 1-page or 2-page piece of paper that says, here's the list of documents that we want to preserve the covenants for. And you just have your attorney prepare that. They'll run a title search for the community, not for every single lot in the community. And they'll just record those particular covenants or record the list of those covenants rather than an actual copy of every document. Okay, it's a lot easier than it was a couple years ago now. But what this preservation is doing is avoiding the effect of this Marketable Record Title Act. That means that you are not going to have your covenants expire 30 years after that root of title. That's what the Marketable Record Title Act does. It basically says, listen, title agents and people that are looking at title shouldn't have to look back 50, 60 years to see what actually encumbers this property. So those covenants, every document that was recorded in the county records, it's no longer going to encumber this property if within those 30 years from the root of title, whether that's treated as the declaration or the individual deeds to the owners, that preservation hasn't been done within those 30 years. Okay, I know that was a little circuitous, so let me say it a little more clearly. If you don't record a preservation instrument within 30 years following the root of title, your covenants expire, meaning you can't tell someone they owe assessments. You can still tell them they owe money that pertains to what you actually spent, but you can't lien for it, you can't foreclose for it until those covenants get revitalized, which is a lengthy and expensive process. Okay, you can't enforce your covenants, meaning that someone that wants to paint their house pink with purple polka dots is technically allowed to do it unless the city comes in or the county comes in and says, what the hell is this? So what you're trying to avoid is that your covenants expire. What will not happen pursuant to Marketable Record Title Act is that the declaration itself expires. The declaration doesn't expire. The covenants do. I'm literally dealing with a lawsuit right now where an attorney alleged that the declaration expired in a certain year. And my response is, you clearly don't understand this area of law. Okay, so moving forward, keep in mind at the first board meeting after the organizational meeting every single year, it is your obligation as a director to mention MARTA, the Marketable Record Title Act, and try and figure out, or have your attorney tell you, more likely, when this expiration would happen. And the purpose of that is to make sure that the association doesn't just allow the covenants to expire without knowing about it. Okay, so that is something that many directors don't know about. Make sure that at the next meeting, if you haven't done it already, at the next meeting of your board, that is something that gets discussed. Okay, you may have had the covenants recorded 3 years ago and you've got another 27 years. Great. But you may find that it was recorded 27 years ago and you've got 3 years to get that documentation together. Don't wait until the last year. My recommendation, start thinking about it 5 years in advance, start preparing for it 3 years in advance, and tell your attorney to get started 1.5 to 2 years in advance of that expiration date. Moving forward, service of process. You got to let process servers in that are trying to serve documents pertaining to lawsuits and things of that nature. You do need to have a licensed manager. And I don't mean you ever have to have a licensed manager, but that your manager must have a CAM license if they are being paid for their work and the association contains more than 10 units or has an annual budget of $100,000 or more, or I'm sorry, more than $100,000. Someone who just performs ministerial functions, administrative stuff, that's not someone that needs to be licensed. So if you're not sure, run it by your attorney is the correct answer. Management standards and indemnity, just keep in mind, if you're working with a management company, you should have your attorney taking a look at that management contract if you're looking to terminate, if you're looking to sign that contract, to make sure that you're being protected. There are some management firms like Sentry and some others that really, there's very minimal that needs to be changed, from my opinion, from the original contract that they're going to provide you to the one that I would authorize you and direct you, as your counsel. I don't get to tell you to sign, but I would say you're okay signing. Okay, because they're not going to include certain things that other management firms include that are totally unacceptable to the association, or at least should be. Okay, but there are others that will include those things. So you're going to want your attorney to take a look at that in advance. Construction defect warranties. I'm not going to go through the whole history, but the bottom line is you now have 7 years, basically from the creation of the community, from a certificate of occupancy, the first CO in the community, to actually file a construction defect lawsuit. I've got several clients that still hadn't turned over at that time. So just understand, you really need to be careful and look out for, are there problems with the way that these homes were constructed individually as members of the community? Or are there problems with the way that the roads were constructed that the association itself needs to go after the developer to deal with those issues? And again, we do have a board certified construction attorney on site in Pompano Beach within the firm that does deal with those issues on a daily basis. So, you know, we don't make that our priority, but we do have an attorney who is highly competent in dealing with not only the preliminary aspect of it, but the litigation itself, if that becomes necessary, and making sure that you're set up for litigation, even if you choose to use another attorney for it. You do have emergency powers. I can't go through them in detail because we're already at 12:49. And that means that I have less than a half hour to get through everything if I want to give you guys some time for Q&A. So I'm not going to go through them in detail, but just understand that what these emergency powers do is allow you to continue your operation in the right way when you're sitting here and dealing with a situation where you've got COVID, hurricanes, states of emergency that have been declared either in your city, your county, the state, or the nation. Okay, and once that state of emergency is declared and there's a determination that that state of emergency might cause damage to the association, that's when these powers kick in, and you have certain rights and abilities that you normally would not be able to do these things. Okay, so just be aware, if we have a hurricane come, which I think I discussed on my radio show last night with the host, that I think we've already got our first named storm of the year, and it's freaking April. But just understand that there is the possibility that these emergency powers kick in sometime this summer. I will pray for every one of you that that doesn't happen, because that means there's a major problem and a major storm and a major potential damage. But you do need to know that these powers exist. My suggestion is, if you've got an emergency kit, take a look at this statute, print out a copy, and have it readily accessible in a waterproof folder. Because these are things that you want to know you have the ability to do that you might have thought you didn't. The other thing is to make sure that you've got an attorney and a manager who are going to be accessible to you during that state of emergency. Not, well, you know, it's a hurricane, we're shutting down everything for the next month. That's one benefit of having offices in different areas of the state, is that if I need to shut down the Orlando office of the firm, I can just tell my South Florida people, hey, I'm directing everyone to you. Please take care of this while I try and survive this storm. The other thing you're going to want to have in that kit, and I think I get into it in a minute, so let's skip ahead until we get to it if it's there. No, we don't. Okay, so let's finish up. What you should have in that kit is external batteries for laptops, cell phones, things of that nature, so that you can use those things as long as the service is still operable and available. You're also going to want to have notepads and pens so that you can write down the things that you need to write down, and you aren't just using your computer to write things down and remember them. You're also going to want walkie-talkies if you're in a community that enables the board to actually communicate via walkie-talkie and the manager to communicate via walkie-talkie. You're going to want those extra batteries for those as well. And there are some other things that you might want to have just as part of your kit. I won't mention alcohol because we're talking about making sure that business remains operational, but frankly, you may need it more during that time than any other. The other thing that I'll mention before we get into budgets is, keep in mind, driver's licenses, you can ask for a copy, you can ask for the information on the driver's license, but you generally can't swipe that driver's license unless the license holder gave you consent to swipe it. What I mean by that is, just like on a credit card, a driver's license from Florida, and I think every other state in the US, has a magnetic strip on the back that gives you access to certain personal information. Okay, you can store the information that you get from the physical driver's license card, but you can't ask and you can't require them to swipe. Okay. Budgets. Okay. This is one of the most important things a community association does. Okay. Keep in mind, what we're talking about is your best guess of what it's going to take to properly operate and maintain your community pursuant to the governing documents in Florida law over the next year. We're not talking about here's the exact dollar figure that's going to be spent over the next year. I have an owner who's arguing that the association should be sued for wrongdoing because they won't provide receipts for what they expect to spend over the next year. We don't have the receipts because we haven't spent the money yet, fool. We also have no relevance to receipts from last year to show what we put in the budget next year, because the budget is allowed to account for inflation. It's allowed to account for things that you're planning on doing next year that you didn't do last year. Just understand, this is your best guess. It's not something you need to stick to dollar for dollar. Matter of fact, if you actually spend exactly the amount in your budget, chances are you either underspent so that you didn't go over budget, or you decided to just use the money on whatever. Frankly, I'd rather see you use the money, but that will mean that you've properly operated and maintained the community. If you try and stay under budget, it means that you had the plan to do something that you chose not to do. To me, that's a bad idea, because you planned, if you made your budget correctly, for what you actually need to be doing to properly operate and maintain the community next year. And if you're underpaying, then I hope that's because your vendor gave you a good break. Because if you, or you didn't need all of your legal budget because you didn't get sued, you didn't sue anyone else, things of that nature. But if you're under budget by 150 grand and it's a $300,000 budget, you either really screwed up the budget or you did absolutely no maintenance that year. And either one of those is a problem. But my best recommendation, make the budget for what you reasonably anticipate, even if that means you have to increase the budget by $1 million this year to properly deal with what's coming up this year. The members get to decide that they don't like your budget and they're going to propose a new one and adopt it. But you have a fiduciary responsibility to propose an appropriate budget, and the members get to decide they don't like it. If you're just saying, well, we don't want to charge the members that much money, you're guaranteeing you can't meet your obligations. That's bad. I know that sounds crazy, but it's bad. Okay, so what you want to do is make sure you're really putting in there everything it's going to take to properly operate and maintain the community. If the members say we can't afford that, your response is, okay, well, we're complying with our fiduciary responsibility to have an appropriate budget and appropriate maintenance schedule, an appropriate operation of the community. If you want something else, you go ahead and propose it, you schedule the meeting, and you vote on that amended budget or that alternative budget more appropriately. All right, notice and adoption. Understand, the budget's not something the members generally get to vote on unless it's an alternative to the board's proposed budget. That is a board meeting, not a member meeting where that budget gets adopted. It is going to require a 14-day notice because assessments are being considered. Understand, when we say regular maintenance assessments, annual assessments, whatever you want to call it, those installments are just your budget divided by the proportionate share of each lot in your community. That's literally all your assessments are. So if you didn't understand where those assessments come from, that's how it's calculated. Take your budget, divide it by the proportionate share of each lot in the community. There you go. That's your assessment. Okay. Non-emergency special assessments require 14 days notice as well. Some will say you can provide just 48 hours notice of the budget meeting. My perspective is and in an abundance of caution, you might want to provide 14 days notice just because some people misunderstand that 14 days. But I agree that under the law, it's just 48 hours. Moving forward, before the budget's adopted, unless the documents require you to provide a copy before that budget adoption meeting, You don't have to send a copy, but you might want to do that anyway so that you don't have to send a copy after the budget meeting. If it's been adopted, the association must provide each member a copy or written notice that a copy is available at no expense to the member upon request. Basically, they can send a records inspection request and get a copy at no charge. If it's requested, again, that's a records inspection request. You got your 10 business days after receipt of the request to produce it, again, at no charge. If you've got a website, again, post it there, you're done. Tell people, hey, go to the website. Now that might change this year with the new legislation that's coming down the pike. We'll see what the governor adopts and does not adopt or vetoes over the next few weeks. You need a budget that says what you're going to spend, what you're going to bring in. Pretty simple, right? You should be using last year's actual expenses plus some factor to plan for next year's budget, not just kind of winging it and saying, well, this is what we had in the budget last year, so we're going to include that in the budget this year. That's not a great idea from my perspective. Money's in the operating section of the budget. Understand, just because you've got something in the budget doesn't mean that's what you have to use it for unless it's an actual adopted reserve. Reserves in an HOA are only adopted by the members by a member vote in the governing documents or adopted by the developer. If you don't have one of those three things, it's an unofficial reserve, and it's basically operating funds that you can use for whatever you need. So just because you said you were going to use these funds for landscaping doesn't mean you can't use them to pursue a lawsuit that you think is important to the association that you didn't have the legal budget for. That's just one example that benefits me a little bit. Moving on. Okay, we talked about what should be included. At the end of the year, something that's not included here. If you've got leftover funds, like I said, you might be doing it wrong, you might not, but if you've got money sitting in that account because you were able to, again, reduce what your vendors are charging you in some way, you went with a different vendor, whatever it may be. If you've got money left over in that account, you've got several options. One is to just put the money in reserves, and I'm not a CPA, but my understanding is that means you pay no tax on that. The alternative is you leave it in operating so that you can continue paying your bills until people pay their January assessments. And you might pay some tax on the overage. It's not profit. It doesn't convert you to a not-for-profit or impact your not-for-profit status. It just might be taxable to the association. So I do hear a lot of people saying, well, we're not allowed to keep money in our account from last year. No, that's absolutely false. Okay, reserves, you are supposed to keep money in your account from last year. Operating, you may keep money in your account from last year. It's just going to depend on what tax ramifications there might be. And again, you're going to want to refer to your accountant to get the answer to that, because that ain't me. Let's see. I think we can skip a lot of this. We talk about certain things that should be in the budget as examples of things that you're going to spend. Things that may be included are not things I think we need to go through. We talk about reserves. There's a difference between deferred maintenance, which is something that's less frequently than a year and results in maintaining the useful life of the asset, meaning you're basically making this thing last a little longer by maintaining it properly, but it's not done every year. Capital expenditures is purchasing or replacing assets instead of maintaining them. Okay, so here's some examples. I won't go through them because frankly, we don't need to. Okay, we talked about how you can create reserves. Computing them is basically, here's how long this item is going to last. So the estimated useful life of this particular asset. Here's what we think it'll cost to replace or repair it when the time comes. And we divide the two together. So on a straight line reserve, it's as simple as it's going to cost 100 grand to re-roof our clubhouse. That roof is expected to last only 10 years. It's a piece of garbage. Or it's already an old roof. Okay. But we think putting a new roof on is going to cost us 100 grand. During those 10 years, you're setting aside 10 grand per year so that at the end of that life cycle of that roof, you've got 100 grand in the bank ready to be used to replace it. Now, reality dictates that 100 grand is not going to be enough because of inflation, because of all of the other things that arise during those 10 years. That 100 grand is not going to be the actual cost. So there are a couple different things you can do. If you've got reserves in your community, to properly account for what you really think it's going to cost. One, you adjust for inflation every year. That's not necessarily going to be accurate as to what it's actually going to cost, but at least you might have enough where, you know, that first year it was 10 grand. Year two, there was 9% inflation. So you add 9% of that 10 grand and you save the new amount in year two. You do the same thing and build and build and build in year three until year 10, when hopefully inflation costs have matched what the increase in that actual project or that asset is going to be. The better alternative is to actually do a reserve study, which is something that's now required for certain components in a condo, but isn't required for HOAs right now. But that would be where you actually have a professional come in, take a look at that roof, tell you what it's going to actually cost 3 years in. And I do usually say 3 to 4 years is about how long you should be waiting before you have another one of these done. And you can do it as to all of the assets of the reserves at one time. You don't have to do it as to each component. But you have a professional come in and tell you, well, you should be putting this amount aside, not the 10 grand, but 15 grand a year, because it's drastically gone up in the interim and you haven't been putting away the right amount over the last 3 or 4 years. So then you adjust in the years after that until you have your next reserve study. So you have a more accurate picture of what you're actually going to need. Now, I mentioned that's a straight line method. The alternative is called a pooled method of accounting for your reserves. That's basically where you shove all the funds into one account. It's kind of like your operating account, and you can use it for each one of these assets that is part of the pool and part of the reserve, as each one is expected to fail. So your goal there is not to say, I'm saving 10 grand for this, I'm saving 15 grand for this, I'm saving 8 grand for this other component. You're saying this one's expected to fail in 2 years. I need to have the money in 2 years for this component. Then we'll worry about the other stuff. So generally my understanding, because I'm not a CPA and I don't look at this stuff on a daily basis, but my understanding is you're going to be putting away less money under a pooled reserve strategy. So that might be one that you want to talk about with your CPA. Let's see, moving forward, changing use of reserves basically requires a member meeting and a member vote. If you want to use those reserve funds for something that is not part of the reserve, your members get to vote. Otherwise, that stays in the pool or it stays in that particular straight line reserve account unless and until your members vote to say, we want to use it for a different purpose. The same thing applies to, we don't want to reserve this year because we don't think we need to, or we don't think it's important enough. We want to spend the money on something else. Okay, that all will require a member vote. It's not just the board deciding our budget's not going to include this year, or we don't like the fact that we're putting money away for the roof because we won't need it for 12 years. So we're going to spend this money that everyone paid to us and we put away for the roof. We're going to use it for something else. Okay, you generally can't do that without a member vote. The vote's generally going to be a majority of a quorum. But look at your governing documents to see if it's a different vote that's required. Okay, we just talked about this. In addition to waiving those reserves, you can also just partially fund them instead of funding the whole thing. Again, member vote, majority of a quorum. You can also vote to terminate the reserve altogether. That's going to require the vote of a majority of all members of the community. All right, moving forward, special assessments are basically any assessment that isn't your regular maintenance. Again, we got a 14-day notice there. No big deal. You're just sending out notice. That notice is going to include a statement that a special assessment will be considered, what it's going to be for. In other words, what is this special assessment paying for? Is it legal expenses? Is it we want to do a project and we don't have the money? Is it we're required to do maintenance and we don't have the money? And then it should also say how much you anticipate the assessment being. That doesn't mean that you're breaking down the per lot cost. It just means here's the total amount. It's easier for the members to vote if you do specify the per lot cost. Now, generally, these special assessments, unless the governing documents say otherwise, are something that the board is going to get to vote on. So the board decides, we think it's necessary to adopt this special assessment because this crucial item is not covered by our budget. It's not going to be something that you have the funds for. Otherwise, you'd just be spending them. It's something that you don't have the money for and you need to collect additional. So moving forward, a special assessment that hasn't been paid by an owner is collected the same way as any other assessment. Now, when I say special assessments, I also mean the individual assessment for self-help that you performed on a lot. I mean any other capital contributions, literally any other assessment that's authorized in your declaration gets collected the same way. Let's see, the notice we said. Okay, so if a member vote for this assessment is required and you can't get the vote, what does the board do? There are two options. One is you basically argue that it is a crucial issue, you must do it, and you levy the assessment anyway. The better option, that's generally more supported under your governing documents in Florida law, is you look to get a loan for the money, and you keep trying to get this special assessment passed until that loan actually comes due. There are a lot of companies, a lot of lenders that will give you the first year or maybe even 2 years where you're only paying the interest. Now, chances are your budget's going to be able to pay that interest. Okay. If not, you might have a bigger problem on your hands because you've under budgeted, and you might need to start by amending your budget, which is another alternative to a special assessment. Okay. So there's a couple things that you can do. Now, keep in mind, if you're going to try and get a loan, sometimes you need to levy a special assessment to pay that loan back before you can get the loan. Depends on your lender. So you're going to want to look for a lender. If your issue was, well, we tried a special assessment, the members wouldn't vote on it. You're going to want to look for a lender who's going to allow you to work around that and let you just keep trying after you've been loaned the money to do what you need to do. Okay, moving on. Financial reporting. This is one that mostly your accountant, your manager, your CPA, they're going to be dealing with. The most important thing to keep in mind, you need to keep financial reports for everything your association is doing. You need to produce those reports within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, or if there's a different date in the bylaws, no later than that date. The board needs to provide every member with a copy of the financials, or just like we talked about the budget, a written notice that a copy of the financial report's available at no charge. So again, you can do that via postcard. That's a simple way of notifying everyone of the budget, notifying everyone of this, and frankly, it tends to be cheaper than mailing a letter to every member of the community or mailing a copy of the financials or the budget to every member of the community. And that way, only the people that actually care enough to want one will get a copy of it. These are the levels of financial reporting required. And, you know, I like to call this the Mo Money, Mo Problems chart, but it's basically the governing documents are going to say the specific requirements of an audit or not an audit that is required for your community. If they're silent, then these dollar figures and these types of financial statements are what's going to apply. So the less than $150,000 cash report receipts and expenditures, that's literally just a spreadsheet of what you brought in and what you paid out. And then we get a little bit more complicated when we range from that 150,000 plus figure to up to 500,000. You're also ranging differently from whether this requires a CPA or not. These last two, the reviewed and compiled, the reviewed and audited financials will require a CPA. The level of review of the association records is really the big difference between all of these. Here in the cash receipts and expenditures, there's zero review of anything. It's just, here's what we got. In the compiled, there's a little bit of review, but you're basically having your person produce the statements, the financial records, based on what's already in the records with no real review or assurance of accuracy. And then we've got some review under the reviewed financial statements. And then the audit is literally, I'm going to look at every piece of paper that pertains to this association, basically all of your official records. That can be valuable. I've actually had the notes to an audit report that a contract hadn't been signed, and it gave the association an ability to potentially get out of that contract that they hadn't bothered to send to me because they didn't think they could get out of it. And the auditor actually noted, hey, this contract isn't signed. Do you have a signed copy? Because we'd like to evaluate what the potential liabilities are here. And the association was able to get out of that contract, not because it wasn't signed, but because that was at least something they were able to use as a threat with the vendor. So there are potentially useful tools and useful tips that are here in these notes to the audit. I don't think that any community should be saying we never need an audit. One time that you might want to get that audit performed is right after the turnover process. The developer is going to be obligated to provide an audit. That doesn't mean that it's in the association's best interest. It's going to be a vendor that was hired by the developer and probably is hired by the developer for every community they've developed. Who do you think the auditor is going to be loyal to? Okay, so just never, I won't say never, but you should rarely rely on the reports that you get from a developer to presume that everything is a-okay. The other thing that I suggest, now that I'm mentioning it, when you have developer turnover to the members, get an engineering study done for the entire community to determine whether any of those construction defects we talked about earlier might be in place. If you already know that there's a problem with drainage or something like that, then you definitely need the engineer to take a look at that specific area. And there are other things that, the water management districts might take care of so that you don't have to, but just be careful with that type of thing where don't just ignore an issue or presume there is no issue because the developer gave you some reports. The members get to change the reporting level. If the board wants to increase the reporting level among those 4 levels we just mentioned, the board gets to do that unilaterally. If you want to reduce the level, the members have to vote on that. And here are the voting percentages that are required in order to reduce that level. That change is really only made for that particular year. So you have to have that vote to reduce the level or increase it every single year. Otherwise, yeah, you're reducing it for this year, but next year you go back to what you're supposed to have, unless you have actual lower revenues, etc. So your actual criteria change automatically. So you do need to have a reserve disclosure in your financial reports. There's statutory language, it's right here. But this is basically if the budget doesn't provide for reserves or fully funded reserves. If the budget doesn't provide for reserves but includes discretionary reserves, you're going to have these 2 things in your financial reports that basically say, hey, we're not reserving for these important assets, and you might end up with a special assessment as a result. So it's literally word for word in bold in large font that these 2 statements, depending on what's accurate, needs to be included in your financials. Keep in mind, even though it's not necessarily part of your financials, there are 2 government filings that need to happen every year. One, the Division of Corporations, you need to actually maintain active status by reporting between January 1st and May 1st of every year, along with a filing fee, your annual report. And then your income tax, which you might or might not have, but you still need to fill out an income tax form, and don't come to me for that. That's your CPA. But that needs to be completed as well and submitted to the IRS every year. Moving on to contracts and bids. Contracts need to be in writing if they aren't going to be performed in 1 year for the purchase or lease of materials or equipment, and it's a service type contract. This is the statute of frauds for the lawyers in the room, all 2 or 3 of you. All written contracts entered into by the association, regardless of what they are, in my opinion, should be in writing. Another issue I see fairly frequently is that there's a contract, which is really someone's proposal that is very vaguely worded, doesn't say a whole lot, and literally just says, I'll do the repairs to the concrete for 50 grand or 100 grand. And I've seen communities operate on that. There's no contract. Pay the $2,000 to $3,000 to make sure there's an operating contract. There are real standards for what the person is supposed to do, the scope, the obligations of each party, the attorney's fees and costs being recoverable if they screw it up, what warranties are involved in the work, the frequency and how long this is supposed to take, basically something that's actually enforceable in court. Yes, that proposal being signed is enforceable, but a judge is going to have to basically guess at what that proposal required them to do. Whereas I'd much rather see a clear scope, have everyone understand what their obligations are before the work starts and before any payments are made, and move forward that way. So again, any landscape contract, even for $3 grand for the year, there should be a written contract, not just an estimate. I learned that the hard way in my personal life by having someone come in and do a bunch of work in my house and didn't really give any concrete contract. It was just estimates. I won't allow anyone in my house to do that anymore, and I'm not allowing my clients to do it if I have the choice. So moving forward, bidding. You do need to get 3 bids for anything that is going to cost more than 10% of the annual budget, including reserves. Now, I say that, but there is a caveat. There are certain things that are exempt from that bidding. I'll tell you what they are in a minute. But important here is you do not accept the lowest bid. You accept the best vendor. That is your fiduciary responsibility. Okay, so you're hiring a manager. They're going to be responsible for most of the day-to-day operation of your community. Do you hire the cheapest one or the one that's actually not going to screw it up? Okay. Same with an attorney. Do you hire the cheapest brain surgeon or the one that is going to leave you intact and able to speak at the end of this surgery? You hire the best one for the job. So you don't have to accept the lowest bid. It's not always going to be the worst to accept the lowest. There are some people that are just giving you a great deal, and that's fantastic. I'm not saying that everyone who is the cheapest is the worst, but don't go based solely on price is what I'm suggesting. The association doesn't need to get bids for emergencies. The association also won't need to get bids for any situation where there is no one else in the county that's actually providing that service. And renewals are generally not subject to competitive bids. Neither are contracts executed before October 1st, 2004. So if you've got a management contract that's been in effect for 20 years and you haven't tossed your manager by then, fantastic. That's great. You probably have someone that's doing a great job. Keep that in place. You don't need to go out and get separate bids unless the board wants to. None of the things I'm saying right now mean you can't get competitive bids. It's just that for these items listed in item 6 here, you do not need to get competitive bids. And it's basically your professionals, including employees, contract services for an attorney, accountants, architects, CAMs, engineers, and landscape architects. The contracts do need to be in writing, which is why we always require what's called a general retainer agreement that all of our clients have to sign before we can start work. That doesn't mean we charge a retainer fee to work with us. We don't have monthly minimums or annual fees. It's just, you want to work with us, we'll do the work we're asked to do. But the contract, the retainer agreement, the representation agreement does need to be in writing, regardless of who your attorney is. Contract with a manager, if it's made by a competitive bid, can be for up to 3 years at a time. So keep that in mind as well. And any of those extensions, meaning automatic renewal, we call it an evergreen term, that's okay too. The contract was awarded under competitive bidding. Any renewal is not subject to competitive bidding, like I said, if it contains a provision that allows a 30-day cancellation. So that's the part I didn't mention earlier. If you've got a 60-day cancellation, you still might need competitive bidding for renewals. An association whose declaration or bylaws provide for competitive bidding may operate under the declaration of bylaws instead of the statute if the provisions are not less stringent than the statutory requirements. In other words, your documents can make it easier for you. Bulk contracts is something we don't really have time to go through because it's already 1:20 and I want to get through everything, which is another 70 slides by 1:30. So we're going to skip through some of this, but essentially just understand that you can have bulk contracts that are entered by the association. If the association is the one paying for it and you pay your assessments, the association can't cut off that service as part of a suspension, etc. And the members can cancel that contract under certain circumstances. Use right suspensions. This is one, please take the covenant enforcement class so that I don't have to go through this right now. But the bottom line is the association has the right to suspend the right to use certain amenities of the community and potentially, if the governing documents say so, suspend the right to vote on member issues. In other words, at the annual meeting, at meetings where amendments are going to be considered and any other issues the members get to vote on, you can suspend that voting right if the governing documents allow it. Your right to suspend use of the common areas with limitations is automatic in the statute. Okay, that's going to require the same thing as fining. So fines and suspensions for non-monetary obligations, meaning violations of the covenants, are going to require a board meeting that the person had notice of. That 48-hour notice is fine. And then a separate committee meeting, at least 14 days notice of that meeting. And If that committee says, nope, no fine, no suspension, you're done. It's back to square one. If the committee says yes, then the fine or suspension goes into effect after you provide notice of the fine or suspension. Okay. If it's for a monetary obligation that you are suspending use rights, you can't fine for non-payment. That's what late fees and interest are for. But for non-monetary violations, if you are suspending use rights or voting rights for that purpose, you don't need to have that second meeting. It's a board meeting, and then you provide notice to the member. Okay. Let's see what we can skip through because we don't have a lot of time. The other thing that I'll point out, people used to argue, and I disagreed. People used to argue until the statute changed last year that you could provide just notice of the opportunity for that 14-day notice of a meeting. The statute's now clear. You have to actually hold the meeting whether the owner asks for it or not and whether the owner shows up or not. It'll just be easier to make your decision if the owner doesn't bother to show. Okay, and when I say your decision, I mean the decision of a committee comprised of at least 3 individuals that will rule on these 3 issues, these 2 suspensions and the fines, that basically decides it can't be and sorry, I'm jumbling a little because I'm trying to get through this stuff real quick. It can't be comprised of any directors, officers, or managers or their family members. And those 3 people are going to decide at that meeting after the 14-day notice whether to pass the violation or not. If the violation's cured before that meeting, the statute is looking like it's going to change this year to say you can't levy the suspension or the fine anyway. If the board votes to levy a fine, that fine for an ongoing violation starts on day 1 after the board meeting. Doesn't start on day 1 after the fining committee meeting. So by the time that committee meets, you're already at your $1,000, which is the max. Okay, you've got $100 per day up to $1,000 unless your governing documents say otherwise. You can lien and foreclose for those fines as of now, only if your governing documents say otherwise. Again, that's a statutory change that might be coming down the pike in the next few months. So I don't want to go too into detail because frankly, it might change by the time someone watches this. We talked about voting suspensions, covenant enforceability. Again, please watch the class. I think that's one of, if I could say you need to watch one class that isn't this one, that's the most important one. But unfortunately, we don't have the time to go through all this right now, but feel welcome to hit it in the Q&A. Self-help versus injunctions. You do have certain obligations to physically go onto someone's property and cure a violation if your governing documents allow you to do that. If your governing documents don't say you can do it, go ahead and go straight to litigation after you send your offer for pre-suit mediation. If you don't know what that means, again, please watch the covenant enforcement class. Assessments and foreclosures. Again, we have a class called, let's see, I think it's assessment collection. Should I pay or should I go? And yes, that was my semi-creativity in naming that class. But essentially, if someone doesn't pay their assessments, you go after them. You try and collect the assessment. Don't let it sit around. And again, this is one of those policies I think every community in Florida should have. So we don't have time to go through all of this, but I'm going to kind of skip through. Understand, again, I would suggest if you're interested in what's going on in your community collection-wise, we do have that class already recorded and on our website to check out. So we're going to skip through the mortgage foreclosure, the bankruptcy, the collection of unpaid assessments. We're going to skip through the insurance, but make sure that you have insurance, directors and officers liability insurance, general liability, umbrella policy, and any damage should be covered. Any lawsuit that gets filed should potentially be covered by an insurance policy. Any claim that you get goes to your attorney immediately, and that attorney should be giving you guidance as to whether it's something they should just handle to save you money, or it will cost you more to have them handle it, and you should send it to your insurance carrier for coverage. Once that carrier covers a claim, generally speaking, they're not going to charge you more than your deductible to cover the entire claim from start to finish. So just understand that that's another dollar. It's basically another bank for where you might get that case resolved. I hate to put it that way, but that's reality. Estoppel certificates are another portion of the collection process that we don't have time to get into, but that is covered fully in our collection class. Again, if you have questions about this stuff, go ahead and put it right into the Q&A that we're trying to get to as quickly as possible so that we can cover some of this stuff if you think it's important to your community. And I promise you, it is important to your community. Fair Housing Act, we touched on already, so fortunately we can skip some of it. We do have another class that pertains to pets, but we also talk about general issues pertaining to these fair housing laws, the Americans with Disabilities Act. But again, fortunately, I know I'm skipping through a lot here. It's going to be probably a good 70 or 80 slides that I completely skip. You'll have access to those slides, and we intentionally make them fairly detailed. If you have questions on what's in these slides, either now or after the class, once you get those, after you fill out the survey, you are welcome truly to reach out to me and ask any questions you have. Recall is a highly technical procedural matter. When you get a recall in, the first thing you want to do is contact your attorney, because you only have 5 business days from when you get a recall petition to hold a board meeting and either certify the recall, meaning the people that are named in that recall petition are off the board, or decide, nope, we're not going to do it. We're not going to pull this person off. And the only reason you can say you're not going to pull that person off is because there was something procedurally wrong with the way that the vote was taken by the members. Now, this recall can be a 10% of the voting interest giving notice of a meeting. Basically, you're having a special meeting of the members in order to discuss the member vote to pull someone off the board, or by written agreement by a majority of the members of your entire community. Okay. Now, keep in mind, if voting rights have been suspended, that doesn't disappear for purposes of this particular vote. So those people still get to adopt the recall. But the attorney is going to look at every single one of those recall ballots to determine whether there's something wrong in them. That's really the only reason to say, nope, we're not going to support this recall as a board. Okay, so moving along, again, just if you get any kind of recall petition, get it over to your attorney immediately. And I mean literally within like the hour, because there is a lot of paperwork that your attorney is going to have to look at. And again, we've got some communities that are 3,000 lots. If we had a recall in that community, it'd be at least 1,501 ballots that we need to review and give an opinion on within 5 business days. I've seen literally times where an entire law office was fully encompassed in this process of reviewing this stuff. We talked a little bit about turnover, so we can skip that. But again, the most important thing is be careful and make sure that the developer is giving you everything they're supposed to give you, and make sure that you're doing your own investigation to make sure that everything that they give you is accurate. Get a copy of the official records, get a copy of everything, all the reports they're supposed to provide. Make sure that you've got everything you can possibly get from that developer, because once they're gone, they gone. And with that, I know we blitzed through the last 60 slides or so, and I apologize for having to direct you to other classes that we teach. That's not me trying to make more money. I make literally zero money teaching these classes. It's truly just because I want to provide the education, but it would literally, well, maybe not literally, but most likely it would take 7 or 8 hours, an entire day boot camp, to make sure that you got all the information I want you to get out of this class. And frankly, I'm sure you're exhausted in listening to me just for the last 2.5. Start with Jennifer, and you can skip hers when you're copying and pasting. That's all.
Okay. Okay.
We were told a quorum of the association members was 50%, not 30%. Can our bylaws require 50%, or does the 30% supersede? It really depends on what the meeting is. My guess is the 30% is going to supersede the 50. That is a procedural issue of what is a quorum, in my opinion, but a judge could certainly say, no, that is a substantive issue. Pardon me, substantive issue, and it requires a separate amendment in order to do away with the 50% requirement. So it's unlikely, in my opinion, but definitely feasible that a judge finds that that 50% is going to apply, and you basically will never have a meeting unless you are really, really successful in getting people to show up.
That's the first batch. It's only letting me do a handful of characters at a time. So
no problem, Jeff. Thank you.
Okay.
Special assessments out for vote. If the vote fails at the first meeting, we go to a second. Can a revocable limited proxy be revoked after the first meeting but before the second meeting? The answer is yes. At any time before that ballot has been counted. Now, if it's been submitted you might have an issue. My suggestion there would be to let the association know, I submitted my proxy, I want to revoke it, and I will submit a new proxy for purposes of the continued meeting. If that proxy wasn't submitted yet, no issue. Angela asks, why would you recommend an association send a violation if it's not enforceable? I don't think I ever recommended an association send a violation notice for something that's not enforceable, but the association might want to do that just to see if they can get the owner into compliance with what they think might be appropriate. So for example, you've got rules and regulations you don't know are unenforceable because you weren't smart enough to get counsel to review them. What I was saying, if I recall correctly, around when you posted this, Angela, what I was saying is, if you're talking about something that is in the rules and regulations that the association doesn't know is unenforceable, you might be sending violation notices that you have no idea have zero effect on the owner. So what I would suggest is, before you ever file a lawsuit, or at least let it reach the attorney, let the attorney do the evaluation of whether the rules and regulations are enforceable. But I agree, you're generally not going to send something that's not enforceable, because then you'd just be wasting your time and money. Rhonda, hi, good to see you. Regarding storage of items being visible, does that mean hedges can serve as that barrier to visibility? Technically, yes, if the hedges are separately allowed. So if your governing documents say you can't have those hedges, you can't just shove them in there so that someone can't see the pavers that are going in the backyard.
Right.
You know, it's generally going to be that it's not visible at all from the adjacent lot. Most hedges are a little bit lower than 6 foot, and frankly, most people on tiptoe or on a step stool or from a second floor will be able to see over those hedges. So I don't know that that will do the trick, but technically that is something someone could do. Mary Beth, deposits, does that include capital contributions? All deposits. But when we were talking about deposits, I think when you were asking the question and we were talking about how the deposits need to be accounted for, that is a separate issue, because we were talking about deposits that are going to be returned to someone. A capital contribution is paid into the association and becomes association money. So that's not what we're talking about when we talk about that particular accounting return of the funds within 30 days. If you pay a capital contribution and you later sell your property, unless it's in a country club that has like a deposit that gets portions paid back when you sell, that's not money that's going to go back to someone. So it doesn't have to be accounted that way. Samantha asks, are email accounts to be turned over to each new director if the email is a separate email made for the HOA? I think that's the easiest way to do it, but there's nothing in Florida law that says you have to turn over those login credentials for that president@hoa.com email. And by the way, I said at that association, it doesn't need to be an email account hosted by the association. I've seen, you know, presidentwaterly@gmail.com, and that's totally okay. I would recommend avoiding AOL.com because that's a little outdated, but you know, that's fine. David McKenna, how often must the directory be updated? Literally every time there's a change to the information. It's got to be an up-to-date roster of the members of the community. We're being denied copies and viewing of monthly financials. Is it a violation? Potentially. It may be that they're not prepared yet. I have no idea. So it would depend on, Terry, your individual circumstances. What you would want to do is, you know, if you're saying you're being denied, send an actual records inspection request. I'm presuming based on the amount of webinars you've attended with us that you've already done that. Your next step, if you believe that the association is not complying with its obligations, would be an offer for pre-suit mediation, which is something we had on the agenda for today but didn't get through. But you might want to check out the covenant enforcement webinar that we teach. We also have a records inspection class that's pending review that hopefully we will have up and be teaching within the next few months.
Hopefully, yeah.
So that's something to look out for. Rhonda asks, how long can an inspection period be? Limited to the number of hours. You can't limit it to anything less than 8 hours per 30 days per month. So like I said earlier, I don't have a problem saying this inspection is only going to go on for 2 hours because I got to get to work. And we don't have a property manager to do this for us, or the property manager's office is located outside of the state and outside of the county, I mean, and we don't want to pay the manager or ask you to pay the manager to drive out here. But No less than 8 hours per month is what you can limit it to. Elise asks, can a records request be made via email? Must it only be through certified mail? It can be made in any way. It can be communicated in any way. It should be in writing. It can be verbal, but the 10-day limitation, the rebuttable presumption, and all of the damages, etc., the presumption that the association intentionally failed to comply only arises when that is submitted via certified mail. Because it's basically a way of proving the association got it and they didn't act on it. The statute makes a presumption that the association got it and intentionally failed to comply. If it's an email, it could have been lost in spam or something else, but when it comes to certified mail, the association is presumed to have received it and has an obligation to comply.
So I want to say from a technical standpoint, anytime you send attachments via email, the chances go up of something ending up in spam or a different folder. So it's always great to follow up, correct, with like a phone call or something that you've sent something via email.
Or agreed, or it's entirely feasible that it doesn't get delivered at all because of the size of the attachment. And
Gotcha.
you might not know that, or you might not know why. So yes, good point, Jeff. Appreciate that. Terry, can a violation of the 10 days be adjudicated in pre-suit mediation? There is no adjudication in pre-suit mediation, and I know I didn't go through that today, so that's an understandable misconception. But pre-suit mediation is basically where the parties sit in a room and try and settle this dispute. That's all you're doing. There's no decision maker other than the parties. So there's no adjudication. There's no judge, there's no jury, there's no decision unless the parties agree on what the outcome is going to be. Terry asks, can the 2 hours pieces be provided selectively or equally to all owners? I would try and treat everyone equally in literally all matters, including this one. But if you happen to have a rational basis to say, today I only have 2 hours, this is when we're providing the inspection for this person. Tomorrow I'm not working, so I can be here for the full 8 hours in a row. I don't see a problem with doing it that way. But if you can provide reasonable time frames for everyone and have it be the same across the board, that's certainly going to be better for your association and for your members. Paul asked, digital copies with expiration. I'm not quite sure what expiration you're referring to here. Shoot me an email if you want this one answered, because I just don't know what that means. Terry, must ballots be counted in public? They should be, yes. Samantha Martinez, the ARC article that homeowners will be notified of approval or disapproval within 30 days. If there is no response either way, where does that request stand for a homeowner? That depends on the rest of the language in that article. If it says you'll be notified within 30 days or it's automatically deemed an approval, there's your answer. If it just says you'll be notified within 30 days and the association doesn't comply, that might be the basis for an owner to demand a response. But it's not necessarily something that's going to automatically deem or result in an approval of that application. Terry says 3 directors elected were in arrears. What's the recourse now? It depends whether they were in arrears as of the date of the date that they could put their names in the hat, so to speak, and be nominees. That's the pertinent date. If the answer is yes, then technically, if you're still within the 60 days, you can challenge the election result and say, we need a new election because 3 of the people that were elected can't serve on the board because they were in arrears. If it is something that they are now 90 days in arrears and they're still on the board, then technically you just make the argument they are statutorily deemed to have abandoned their seats and the remaining directors need to appoint 3 new directors. Terry, can you see what's accomplished in pre-suit mediation without continuing to litigation? Only if there is a written agreement that's reached as a result of that pre-suit mediation. So if not, that mediation process is completely, I can't think of the word right now because my brain is mugged, but they are not subject to disclosure. It's something that's confidential. Thank you. I guess I've been talking too long. That mediation process is confidential. So the result is not something that anyone other than the mediator, the counsel, and the parties get to know what happened. There might be a report that actually says that either there was no settlement, there was a settlement, or there was a partial settlement. There might be a settlement agreement. If there's not one of those things, there's not going to be any documentation that you're entitled to get if you're not a party to that mediation or the attorney or the mediator. Denise asks, so did I hear correctly that the president of the association doesn't vote on issues? Let me be clear on that. And I thought I was during the webinar, maybe not. The president gets to vote as a member at member meetings. The president gets to vote as a director at board meetings. But being the president does not automatically make you a director or a member of the community. You vote only in those capacities at those types of meetings. So I hope that clears that up. Can you define conspicuous? It means that it is open and obvious. You can look at whatever the thing is and tell that this is what we're talking about. Terry asks, one director has no laptop and owner gave director a laptop so they could read board package. Great. I'm glad they were able to read it. I don't know what the question was though. The verbatim language of the motion should be included in the minutes. Yes, absolutely. John, does the statute cover how long my certificate is good for? I attended this class once before. Do you need to attend every 5 years? As of right now, it's good for as long as you serve on the board. The association should be keeping the certificate in its official records during that entire time. The minimum time frame is that 5 years that you mentioned. You don't need to attend every 5 years right now. However, there might be educational requirements coming down the pike, depending on what gets approved by the governor, that might require you to take this class at least once and additional education every year. That just depends what actually gets adopted and what doesn't this year that's being proposed right now. Barbara asked, you mentioned at the beginning that docs should have chapter 720 stated. What if the declaration and bylaws say they're adopted under 617? Can you comment? Yes, I can comment. That's fine. Keep in mind, some of these communities might have been adopted and created before 720 even existed. So, excuse me. So what we're dealing with is essentially chapter 617 is still going to govern your community. And whether your declaration says so or not, if you fall within chapter 720, 720 will also govern your community. So the fact that it doesn't say it in there is irrelevant to whether or not you're governed by the statute. What I was mentioning was, if your declaration does refer to 720 and automatically adopts future amendments to that statute, then the amendments will apply. They might not apply if that language isn't in your documents. So I hope that clears that up. Rhonda asked, can we create a reserve fund for legal fees based on very litigious members? The answer to that is you would need, if you don't already have that reserve in place, you would need a member vote of a majority of the members in the entire membership in order to create that reserve. But yes, you can actually absolutely do that. Terry asks, oh, it skipped back. Notice of special meeting listed several enclosures. None were included. We believe this violated the 30-day notice and is voided. I think I already answered that in text, so I'm not going to address what looks like the same question. Rhonda, bidding. So do we need competitive bids for expenses less than 10% of the annual budget? The answer to that is nope. Martin asks, if a previous board signed a contract higher than the 10% threshold without competitive bids, is the current board obligated to honor the contract? Yes, unfortunately, that's not really a basis to get out of the contract unless you're able to argue successfully that there was zero authority for that board to actually enter into the contract. I don't see that being successful, but it might be something to discuss with your counsel as to whether or not that's an option. Jennifer asks, what documents are included in official records open to inspection by association members? Does it include the property notebook that lists violations by property? Yes, it does. It's literally every document except the things that the statute says are not subject to inspection. Any document, whether it's any written record is actually the language of the statute that pertains to the operation of the community is included. So yes, those violation notices are official records and are subject to inspection. The violation notebook, same deal. It's a written record that pertains to operation of the community. So yes, it's subject to inspection. Question 2 from Jennifer, does association member who records an HOA business meeting have the right to post the recording on Facebook? Not necessarily. But you're in a public meeting, you don't have a right to privacy. The member had the legal authority to record it. So unless you've got a policy in writing that has been adopted by the board that says you're allowed to record any meetings pursuant to Florida law, but you may not share them in a public forum, technically there's really nothing you can do to say that they can't share it. You can still send a demand, going back to the question earlier about why would you demand something, someone not do something that's unenforceable. You can send a demand and basically say, just understand, whether we're able to sue you or not, we plan to do it. And you wouldn't come out and say it that way, but you would say, you know, if you don't take this down, just understand we're not only reporting it to Facebook as not really your property to share with the world, but also something that is a violation of the covenants. But strong recommendation, if you don't want people to be able to share that, either amend your declaration or more likely adopt rules and regulations, including that policy regarding member participation at meetings that says you can take the video, you can share it with all the association members and with the association council, but you can't unilaterally decide to post it on your website or on social media. How the board, Ron asks, will you briefly recap if or how the board can remove another member? You can, so I talked about how you can remove officers from their officer positions. To remove another director, you need a recall or an election. That's it. Or you need to find that they did something that will automatically have them removed. They didn't pay their assessments or some other monetary obligation for 90 days. They stole money from the association. They accepted kickbacks, things of that nature. Anthony, what about the law that legislation trying to put through that you can't go after non-payment of HOA fees, cannot put liens or go to foreclosures on non-payment? That's not anything that anyone is really pushing forward right now. There is legislation that is being pushed through that you can't do that for fines, but not for unpaid assessments. So with fines, my understanding is you're basically putting in, if the legislature that's being proposed passes, that you would only be able to foreclose, even if your governing documents say you can, if the fine exceeds a certain threshold. I feel like Mike Tyson, sorry. Certain threshold percentage of the property value. So that, I'm not aware of any legislation that's even being considered right now that would say you can't foreclose for assessments, even if you talk about fines as assessments. Ronald asks, can non-US citizens be restricted from being board members? Nope. As long as you're allowed to live in the community and your governing documents don't say that there are specific limitations on who can serve as director. And frankly, even if your governing documents say it, the Florida statutes say that pretty much anyone that isn't subject to one of these problematic behaviors can serve on your board, regardless of what your governing documents say. Samantha asks, as the last question of the day, waterfront properties, lake and retention pond, fencing, sheds, backyards, what is allowed when there's nothing in the declaration and covenants? Anything's allowed, unless it is on an easement, because you said this is a drainage easement based on the land survey. If it is going to interfere with the use of the easement for the intended purpose of the easement, the association, if the association owns the easement, meaning you hold the easement, it's in your benefit as an association, the association can probably tell them they can't put those things in the easement itself. The issue is privacy for the homes just on the small easement from the pond area, and homes are physically able to look right into the home behind them. This is different from the distance that the lake area has. So if the concern is privacy, then the owner should be able to create that fencing, sheds, keep that blocked off and keep that privacy by having a shorter yard, if that's their concern, without interfering with the easement. But generally speaking, you cannot interfere with an easement by installing or storing something on your property. So I hope that answers all the questions. I have nothing else for you other than a big thank you all for attending today. And I am going to go and maybe eat my lunch that's been sitting here for an hour. And I thank you all for being here today. I hope everyone got a lot out of this. I know that I kind of blitzed through the material. And unfortunately, when you've got an 8-hour class to teach in 2.5 hours, that's kind of what you got to do. You got to skip some of it. So if there are any questions, I genuinely welcome you to reach out to me. My email address is in the slides. It's also right on the screen all day long. It's as@kbrlegal.com. Thank you again to Sentry for hosting us today. You know, we really appreciate the opportunity to work with a management firm that I actually respect. And we only really do this with management firms that we respect. But that said, thank you again to Sentry. It was great to be here today, and I hope everyone got a lot out of it. Feel free to reach out anytime.